All rise. The Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Commissioners, before I call Ms Weston, I might just run through the day's events. First, as I've mentioned, we have Ms Glenda Weston, who is a lived experience witness. After morning tea, we'll have Mr Danny Liversidge, who is also another lived experience witness. And then after lunch, we will have the Honourable Jennifer Coate, AO, Dr Ian Freckleton, AO QC, and Mr Hugh Dillon, which is an expert panel on coronial inquest.
Thank you, Mr Shepto. And just before we start, I do also want to acknowledge serving and former members of the ADF who may be with us today.
Thank you, Commissioner. Commissioners, I call Ms Glenda Weston.
Miss Weston, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Yeah.
Ms Weston, am I correct in saying that you are giving evidence to the Royal Commission this morning because your son, Private Bradley Wayne Carr, died by suicide on Anzac Day, the 25th of April 2019, after serving in the Australian Defence Force?
Yes, you are.
Oh, you just say yeah. And how old was he when he passed away?
Bradley was 34.
And that photo on your desk, can I just ask, that's a photo of your son?
It is my son, yes, Bradley.
And when and where was that photo taken?
That was taken at Kapooka on his march out in 2007.
Before we proceed any further, I'd just like you to know that if at any stage this morning you'd like to take a break or pause, just please let me know. We're happy to accommodate you in any way we can. Also, if there are any questions you don't want to answer, please just let me know.
I will.
Finally, I'd also like to add, on behalf of this Royal Commission, that we're very grateful for your participation here today and for the courage you've shown, so thank you.
Thank you.
Ms Weston, in terms of your evidence, am I correct in saying that you have made a statement signed 10 February 2022 in response to a notice to give that was issued to you by the Chair on 7 February 2022?
Yes.
Commissioners, as you are aware, there are two versions of Ms Weston's statement. There is a confidential version in which personal and confidential information has been redacted, and there is also an unredacted version of Ms Weston's statement, which will be covered as a confidential exhibit by the general non-publication order that has been made by this Royal Commission. Operator, can I please ask that the redacted version of Ms Weston's statement, which is document ID GWE.00001.0001.001_R, be displayed on the screen? Sorry, Ms Weston. And operator, can I please ask that you scroll down to the next page? Ms Weston, do you recognise this as the statement you provided to the Royal Commission?
Yes, I do.
And to the best of your knowledge and belief, is the statement you have provided true and correct?
Yes, it is.
Thank you. Commissioners, I tendered the redacted version of Ms Weston's statement, being document ID GWE.000.001.001_R as a non-confidential public exhibit, and the unredacted version of Ms Weston's statement, which is a document ID of the same name but without the same numerals but without the _R at the end, as a confidential exhibit.
Yep, accepted. Thank you.
Thank you, Chair. Ms Weston, can I please start by asking you to tell the Commissioners a little bit about yourself?
I prepared something here. I was born in Ayr, a sugarcaning farming town in North Queensland in 1960. My father sold his cane farm and we moved the family to Western Australia, to Western Queensland, managing sheep and cattle properties for most of my life. My early childhood was happy and exciting, living life to the fullest alongside my two brothers, working horses, cattle and dogs, my true passion. In 1974, our family relocated to Charters Towers, a mining town 1.5 hours inland west of Townsville, where I continue to reside. I've had 2 marriages and have been blessed with 2 children and 2 wonderful stepchildren. Between 1996 and 2006, I owned and operated a florist shop alongside my daughter. We offered all nature of floral arrangements as well as baby wear and nursery furniture. In 2010, after my second husband was diagnosed with terminal lung cancer and a brain malignancy, I cared for him in our home until he passed away 5 months later. It was just after this time that my daughter suggested I try a different direction in my life. I studied at home and online to achieve qualifications as an AIN, assistant in nursing, wanting to give back to the community that helped and inspired me immensely during my husband's illness. I worked for 4 years as an aged care in-home support worker through a well-known and respected community nursing organisation. I thoroughly enjoyed working with and supporting our local elderly, some of whom I developed wonderful friendships with and knew well from the time in my floristry business. However, when the opportunity arose to work with my true passion, animals, I purchased a busy mobile dog grooming business and my life just fell into place. I was truly happy. Unfortunately, since the tragedy of my son's death in 2019, I sink myself into work 7 days a week, and that's just to keep my mind and my body exhausted enough to sleep at night. I am eternally grateful to have the business and my family. It's been my only saving grace.
Thank you. Now, can I just ask you some questions about your son, Private
Yes.
Carr? Can you please tell the Commissioners a little bit about him? What was he like as a boy and as a young man?
Bradley was born in Charters Towers in 1984. He was a very excitable child. He enjoyed his life immensely. He loved animals. He was a very caring, kind person. As Bradley, he was educated in Charters Towers. He went to Thornborough College in his senior years, and then he developed a love for inland skating. He travelled to Melbourne in 2000, and he participated in extreme games. So that was a good time for him. Brady decided then he really wanted to join the army, and for a good while we knew nothing about that. So letters started coming in the letterbox, and we found out that he was really fully intending to do this. So we supported him, and then he joined the army.
So are you happy with him joining the army?
I think, yeah, we were excited for him to join the army. First we didn't really know what he was going into, and if he was doing it for any other reasons, but he did have mates in the army at the time, and so we were happy enough. I think it was we felt it was a good stable life for him, and that he would succeed in it. So.
And roughly how old was he when he joined the army?
Brad was about 22.
22. And after he joined, do you know where he trained and where he was posted?
He was posted to Kapuka for his training. Then he went to Singleton to train as a rifleman. That was he wanted to be a rifleman, that was it. And then he was transferred then to Townsville.
In a moment, I'll ask you about his deployment to Afghanistan, but before I do that, can I ask, what was your impression of his experience in the army before he deployed? Do you think he enjoyed it?
Brad loved the army. He absolutely loved it.
Good soldier?
He was a very good soldier. He He received an award for the most outstanding soldier at Singleton before he passed out at Singleton. So
Now, in June 2009, which is about 2 years after he joined the army, he was deployed to Afghanistan.
yes, he was.
Was he excited to deploy?
He was to start with. Time came closer, he started to have doubts. He came home, discussed that with his stepdad and myself, and his stepdad told him if he had any issues with that, he should think about it, and if he did want to go, no one was expecting him to go. So there was no pressure on him, but I, on the other side, decided that I just felt that he needed to complete something, and I spoke to him in that way. I just said, mate, I think, there's something you need to complete. You join the army, and you'll regret it if you don't go. And he did. He went.
And what is your understanding of his experience in Afghanistan?
Brad enjoyed his experiences in Afghanistan. He came home. He was happy to come home, but I do believe he enjoyed his time over there.
And about when did he return home?
Sorry?
And about when did he return home?
He arrived home in February 2009.
So it was...
2010.
10, okay.
10.
So he was there for about 8 months?
Yes, he was. He did an 8-month deployment.
In your statement, you say that as soon as Private Carr walked into the room, you knew that he was different. Can you please explain to the commissioners how Private Carr had changed and any reasons for that change?
Bradley, he didn't seem excited to be there. His eyes were very glazed over. He had very bright eyes, Brad, and they were just very glazed over. And Bradley appeared to be extremely angry when he walked through the door. He was different.
So you noticed that immediately?
Absolutely. Immediately.
And what was he like after he returned from Afghanistan in 2010? So perhaps starting with that first night, can you please tell the commissioners about your interactions with your son after he returned, but perhaps while he was still serving in the army?
Bradley, the very first night he returned home, he was so angry. I couldn't believe what I was seeing. And then it just progressed. So every day after, Bradley's aggression increased. Some days he was back to being Bradley. It was nice to see him. And then other days when he was angry and aggressive, it was intense. It just progressed from there, the anger.
Are there
and
any...
anxiety.
Yeah.
He suffered terrible anxiety.
Are there any incidents that stand out to you throughout that period? Or
There are a lot of incidents.
any that you'd like to talk about, or none at all?
Would you like me to talk about the time he came back from when I was travelling home?
Sure.
And he came, I think this was before he was discharged. I went to pick him up, bring him home, the hour and a half drive on the highway, and there's a very steep built up stretch of road there. I was doing 110, which we do, and he just immediately said, "Mum, stop the car." And we were talking fine, we were laughing. I don't recall exactly what we were talking about, but I know it was an angry situation. But I slowed down, he said, "Mum, stop the car," and he started to yell at me. So I tried hard to slow up as fast as I could, but I was probably doing about 80 when Brady opened the door and flew out. And I was mortified. I slowed up, I stopped, I started to reverse back. I saw him pick himself up out of the dirt, and I almost got back, reversed back as far as I could, and he started throwing rocks at my car. And this was very intense. And I said, "Brad," he said, "Get, just get." That's all I could get out of him, get. And I thought, what have I done? I got up a bit further, I called one of his mates, and I said, "Please come pick him up, he's not in a good place. I don't know what's happened, but Brad needs to be you to take him back to town, so he's not coming back to Stairs with me." So one of his mates did pick him up, and many years later, it wasn't straight away, it was when Brad started to open up a little bit because he was so closed before that. He told me that he had seen culverts on the side of the road and it had triggered him, and he wanted me gone, out of danger. He didn't want me to be there. He was terrified I'd get hurt. These are things that we put up with for years.
Yeah.
The
This is just
triggers.
one example of the things that you were living with.
Yeah.
While he was still in the army as well.
He was still in the army, yes.
And it was at some point throughout that period too that he was accepted into the SAS course.
He told us about that when he first came back. That was immediate. He
Right.
said, "I'm ready to roll. I'm going to join SAS. I'm going to train." he was going to Western Australia. And I really didn't feel he was right for it. He was physically fit, but I just didn't think he was mentally fit for it. And he didn't go. Everything escalated so quickly that I think he realised he wasn't ready either.
Yeah. Can I ask the operator to please go to the page in the statement ending .0003 and to display paragraph 29, please? It'll come up, but I'll summarise it. In that paragraph, you refer to a conversation that you had with your son after he was discharged from the Army in 2012, and he told you that he had a deployment at home, but that the soldiers all want to tick the right boxes and don't want anyone to think there is an issue. After that, there was no follow-up. Can I ask, do you think that was sufficient? And if not, what do you think should have occurred?
I knew nothing about debriefing when he first came back, but I was told later that they do a search home. And these boys, they want to come home. They don't want any problems. They don't want any issues. So they tick all the right boxes, basically. I really don't think that's good enough. My opinion, I really feel they need to come home and have an area where they can be debriefed, where they've trained them hard, and they are very hardened soldiers, and they've seen the worst of the worst. They need to come home then to become civilians. There's not enough input into returning them back to social life. They're still soldiers. They need to be able to hold themselves again once they come back into public life. And this is where the aggression comes from the field. Right. They're not in the field anymore. They're back in civilian life.
Yeah.
I just don't think there's enough concentration on that area.
So that's something you'd like to see put a lot of effort into?
Definitely.
Just given your experience and your reference to soldiers ticking the right boxes, do you think that Army members feel comfortable coming forward and reporting their mental health issues?
Absolutely not.
And why not?
Because they're suffering in silence. They think they're the only one it's happening to, and they feel ashamed. They've been to Afghanistan, they've worked with their unit. When they come home, because they don't see anybody else seem to be suffering from what they're suffering from, they try and hide it. So they really keep it quiet as best they can. But unfortunately, because I feel it's an illness, it progresses.
And is that how you feel it happened in your son's case?
Yes, yeah. Absolutely.
While he was still serving, do you think the Army knew that he was struggling?
Oh, they did.
Right, and why do you say that?
Well, like I said, I have a lot of medical reports at home that tell me, so, yeah.
And in your statement, you refer to him being diagnosed with PTSD in around November 2011.
He was.
Now, he was still with the Army at that time?
He was, yes.
So do you know if he received any medical or mental health support from the Army for either his PTSD or the other issues that he was experiencing?
He did receive treatment, but that's when the medication started. Right. And I really feel there was just too much medication prescribed. This is where our medications start.
Well, this is something that you raise in your statement. This is one of the key issues that you raise. You talk about over-medication. Can you please tell the Commissioners maybe a little bit more about your son's experience with that?
He was diagnosed with PTSD and the medication started coming. He had a lot of pain also from injuries that were accepted injuries. So the more pain he had, the more pain relief he received. And in the end, he would take so much home that he could prescribe whatever he needed. So more pain, more medication. I don't know what to
Is
say
this-
about that.
This is so just so I'm clear on it, this is something that started while he was in the army and then continued after his discharge in 2012?
It did.
And who was prescribing him these medications?
All DVA doctors,
Right.
yes.
And what type of, do you recall what type of medication it might have been or what he was?
Well, he would have
taking?
endones and Oxycontin for pain. He would have diazepam for his stress, Panadol. He was on a lot of medications. Suboxone towards the end, still Nox for sleeping. He couldn't sleep. The biggest problem Brad had was lack of sleep. And because the minute he closed his eyes, he would have his flashbacks. And so the flashbacks, he chose not to sleep, so his mind wouldn't let him sleep because the minute he closed his eyes, he would have flashbacks. So the medication was, for sleeping, and then he'd be sleeping all day, so he would have anxiety. He couldn't go to a supermarket because of anxiety. He would have to dose himself up with anxiety medication, which is diazepam. It made him sleep. It would make him drowsy, not sleep. So there was one thing after another. He was having pain relief, which I felt made him aggressive, and they were addictive. They were opioids. So they were very addictive, and the more he took, the more he needed, because the more it took to cover the pain.
Well, as an assistant nurse, I mean, were you surprised by this?
Or
are you surprised by this?
I was horrified with the medication that Brad was on. I just feel the human body couldn't take that.
And what would you like to have seen have occurred differently?
A lot more. Brad needed to talk. The biggest problem is they won't talk. They won't talk about things because of confidentiality as well, I should imagine. But they do need to talk. You say start talking to Bradley and he would close up. So, and he was also ashamed that he was in that position. So there was, it was just one thing after another. It was a build-up of a lot of different things, Brad.
So you think it's about sort of providing a supportive environment in which you can come forward and say...
There needs to be a lot more understanding about the conditions. There needs to be so much more understanding, and I don't think there's enough. There isn't enough. So they just give the medication.
Well, in your statement, you say that instead of being provided by the support that he actually needed, which is along the lines of what we were just talking about, he was discharged. Do you remember roughly when he was discharged and the reason why?
Bradley was discharged on, he was supposed to be discharged on the 11th, but he didn't make it that day, so I took him in on the 12th, so he was discharged on 12th of July 2017.
11
Oh,
July
sorry,
2012.
2012.
I think, yeah.
I don't know where the 17's come from.
That's all right.
Yeah, it's 2012.
Yep. And do you know the reason?
It was a medical discharge.
It was
Bradley
that-
was unfit.
Right, medically
work.
unfit. And was that because of his PTSD?
It was.
Now, I'd like to ask you just about some of the events around the discharge, because in your statement you refer to some distressing events that occurred around that time. Can you please tell the commissioners, how did your son react to his discharge, days before, days after? What happened?
It was dreadful. So I was there when he discharged, and that night I didn't want to take him home, so we went to a motel. Bradley Commando crawled all night under the beds, around the beds, and then in the morning I was terrified. That was probably the first night I was really, really frightened of Bradley. And the noise, the screaming, and I was worried because we had guests in the motel. In the morning he told me that he had a dreadful night. He didn't sleep a wink and he was outside smoking. And I just looked at him. The next day we went back to his house, and he had to be out of the house because it was an ADF house. So him and his partner had separated at the time, just recently before that. So I went to help him clean the house up. And we got a storage unit in town. I started transporting things to the storage unit. And then 2 days later, on the Saturday, early hours in the morning, I received a call from Bradley, and he seemed fine. Normally I could read into his calls, and I really had no reason to worry about it. My daughter and I decided to go to Townsville the next morning to have a bit of a day out, and I thought, well, I'll stay the night and help Bradley take some of the bigger things to town. and got to his house, and he tried to take his own life. So then it was bedlam from then on. 12 days we had spent in hospital. It was a pretty horrific time. It was really, no one could understand what it was like. It was hard.
We were talking about his discharge, but that wasn't the only issue that he was dealing with around that time. You refer in your statement to recently finding out some information about another issue that your son was dealing with, which is military charges. Now, the name of the person who told you this information is confidential.
It is.
But can you please tell the commissioners about what this person told you?
He told me that charges were being pressed upon Bradley, and they were to be made harsher. And when this young person presented the charges, his commanding officer told him he had to make them tougher. Really, really tough, not tough enough. So I just feel transition's not a great thing either.
In your statement, you refer to it being trumped up charges.
They were trumped up.
Now, this person also told you something else about when you were in hospital with Bradley just 2 days after his discharge and after his suicide attempt. You made a phone call to the barracks?
I did.
Why did you make that phone call to the barracks?
I needed help. I desperately needed help. I
And
didn't know what to do.
And what was the Army's response?
They were sympathetic when I called, and then this young person wanted to come up and talk to me, and he was told not to be in dress uniform, that Brad was not part of the Army anymore, and there was nothing more they could do to help us, and that was it. He's gone. He's not part of the Army anymore. He's not our responsibility.
So just focusing on that time after he was discharged, can you please tell the commissioners about perhaps how that was? So from the period from 2012 to 2019, some of the things that you're experiencing throughout that period?
Just after he discharged and we had him the 12 days in hospital, can I also mention that 2 days before he was discharged, he tried to step in front of a vehicle. So that was also before he actually discharged. So I kind of put that together, that it was a pretty bad time of his life. Discharging was not a good issue for him. I think he didn't really want to discharge.
Yes.
And then after that, I was desperate because all the lead up to that, well, like long before even he discharged, there were so many incidents that were huge to us, and I couldn't cope anymore with the problems that we had. I couldn't. So I tried so hard to get Brad into some form of an institution. I just needed him to have something that would fix him. I thought by getting him to an institution, it would actually fix him, how silly was that? So we got him into Greenslopes Repatriation Hospital. And then 2 days later, I got a call from the doctor asking me to come pick Bradley up and bring him home because they couldn't have him at the hospital. So those few weeks after that were so hard on us in the house because Bradley had, like he was still very wound up from those issues he had just the weeks before. So I didn't know, I didn't know what to do. I didn't know how to handle that aggression and the way that Bradley was. I didn't know, I couldn't handle PTSD. I didn't know what it involved.
And is that something that sort of just continued throughout that
Continued.
7-year period?
It just got worse. We thought it was bad, but it was to get worse.
PTSD wasn't the only thing that he's dealing with at that time, because in your statement you refer to a number of injuries that he had as a result of his service in the Army, and I'll read those out for you. It's knee problems, shoulder problems, bulging and herniated discs, bursitis in his left shoulder, lumbar spondylosis, a torn ACL in his right knee, and a lower back injury. And you say that he required 4 operations.
He did.
Is that correct? And this was just after discharge. Can you please tell the commissioners, was he able to get those operations?
Bradley received a white card, and always Bradley had no money. He needed a gold card to get those medications, those operations, and he fought hard for 6 years to receive that gold card. So he received no operations whatsoever until he received the gold card in 2018, and he had his first operation on his left shoulder in January 2019.
And was there any other support that he was trying to access throughout that 6-year period that he couldn't because he didn't have the gold card?
He was constantly sent to Cairns, to a clinic in Cairns, but it was in and out, and then the trouble would start again. Then it was in and out, and the trouble just started again. It didn't just start again, it was continuing. So he was always in and out of something for a short term and then back home again. And like I said, I'd do his shopping. I'd go to Townsville and do his shopping because Bradley could not go into a supermarket. He couldn't be amongst people. Bradley was in the end not living a life whatsoever. He was just running his own little life. He would be on his own most of the time, and he was very, very lonely. And like I say, PTSD has that effect.
Yeah.
That's what it does to our boys and our girls.
You mentioned in your statement that he wanted to attend the Coronial clinic, but again, that he couldn't do that because he didn't have a gold card. Is that right?
It's quite expensive to be in the Coronial clinic.
Yeah.
Brad couldn't afford to do it himself.
Yeah. So he needed the gold card assistance to do that.
Yeah, but I do believe, though, he was in the Coronial clinic before he received the gold card. When he went down in 2017, I think he was in the Coronial clinic in early 2018, but that's when he received his gold card.
Right. And what was your impression of the support that was provided there?
I believe when Bradley finally got to the Gold Coast, he was receiving excellent treatment, but it was way too late. If that, I figure that if it happened a lot earlier, it might have been a different story. Bradley suffered right through until it was right through until 2018, and he had 12 months then after that didn't he?
Well, can I ask then, if he had received a gold card in 2012 and not 2018, do you think it would have made a difference?
I figure it would have made a big difference.
Do you have any suggestions for how DVA might improve?
They have to stop changing the goalposts all the time. Bradley was the one who dealt with DVA, not myself. He was the one who he dealt with. So, but every time he would call me, he'd say, "Mum, I'm just about there. I know I've got my gold card," and then it would stop. He said, someone wasn't there, or no one signed a paper, or they they dropped my points back. So there's a point system, and every time he got almost to that point, he was knocked back. So the impression that makes on them, it just depresses them. It just puts them back again, way back, years back. So they start again, and they fight again. The goalpost is too far away. And they just don't have that fight left in them. As the years go by, they lose their fight and their drive.
It's just too long. Can I ask you then a question about his death by suicide? In your view, what are the most significant factors that you believe contributed to that?
Exactly what we're talking about was what contributed to Brad's death. From start to finish.
Yep.
It was just a journey that was to end. It started and it just ran its course.
It just kept getting worse.
It just ran its course.
Can I also just ask, because he took his own life on Anzac Day, was that a difficult day for your son?
It was an extremely difficult day.
And why was that?
The first few years after Bradley returned from deployment, it weren't too bad, but every single year changed and it got worse and worse. My daughter had a floral shop. She would make a lovely window display for Anzac Day because in her paternal side there was also Anzacs. In the end, Bradley resented his sister for putting that window display on. He became aggressive with us as a family because we didn't understand. And I think the aggression was actually within. I felt that he was angry with himself for not being able to deal with any issues anymore. I think it was a thing within. So he took it out on his family a lot. And we did. We were very proud of Bradley. We loved everything about him and what he did. But he made it harder for us to be able to enjoy those times with him to honour him and his comrades. So he kind of took that away from us. So because he was taken away from himself, and in the end, Bradley could not face those days. He couldn't face them. He tried to. He'd get himself all revved up, and then the day would come and he would disappear. He was lost.
Yeah. It was just a very significant day for him.
Terribly significant, yeah. It was too much for him in the end.
Thank you. Can I ask, in your statement, I'll just mention a few things. You raised three key issues or concerns, and we've already spoken about DVA and we've already spoken about over-medication, but one of the other key issues that you raise is what you describe as early intervention. Can you please explain to the Commissioners what you mean by early intervention and what type of support you think should have been made available to your son?
A lot of the boys and the girls, they come back and they are dealing with it okay. And I think the biggest issue is that some can't handle it. So I believe the ADF should be noticing, they should be noticing discrepancies with them. So they need to bring it up at an earlier time. Like I said, early intervention is what they need to be. They need to be looking for those signs. Instead of, like, when they become disruptive and aggressive and they go AWOL, they don't turn up for work and they have to go looking for them, they must realise there's something bad happening. And it's not they don't take notice of it. They press charges, or they make it harder for them, or they get punished. They need to be aware, the ADF need to be aware, they need training beforehand and they need training after. So I just think it's an issue that I can't tell the ADF what to do, but they do need to look at these issues and be aware of them and then concentrate on the ones who are suffering.
Actually, can I ask, was that something that happened to you private car? Did he go AWOL?
He did.
Right.
Quite a few times.
Right. So that was something, as you say, that was a bit of a trigger point that perhaps could have indicated something else.
Well, my my second husband was diagnosed with cancer when he first arrived home from deployment, and then we suffered as a family. So I do believe that he was very close to his stepdad. So I believe the trauma of that as well as coming back and seeing the trauma he had seen as well on deployment, it just accumulated.
Yeah.
And it was just too much for his mind.
Too much. So far, I've asked you a lot of questions about the support that you believe should have been provided for your son, but for 9 years you're dealing with his issues and many other things in your life. What about you? What type of support do you think should have been provided for yourself, or what would you like to have seen provided?
I was offered counselling towards the very end, but I did offer the counsellors my counselling because by that time I think I was pretty educated. But to start with, I got nothing. Like I said, the first offer of help didn't come at all when I asked in 2012. We were refused. We were nothing. There was nothing they could do for us. And I think that was pretty horrendous. The very first time was horrendous for us, and we didn't know, we were floundering, we didn't know what to do. And that continued right through. So we did the best we could as a family, and our whole lives in that entire time was Bradley. We focused on Bradley. We did everything we could because Bradley's life was hard, and we were trying to deal with it as a family. And it really took its toll on our family. It really did. Yeah. Look at us now, you know.
Can I just ask, just when you refer to that first request for help, was that the one that we were talking about earlier about the hospital call, or was there
No,
another?
that was when I called the ADF when
This is
on the
another
Saturday.
request for help.
No, this is when he tried to commit suicide, and I called the barrack and I asked for
Yes.
help, and they said no, they weren't going to offer us anything.
Yeah. Can I ask, just before we move on, are there any other sort of key issues that you wish to raise for the Commissioners this morning in understanding what may be causing defence or veteran suicide, or what might be done to prevent it?
It's not a not like I said, not everybody comes back and suffers PTSD. So it's not something, but once they do have PTSD, it progresses. I just don't think they know enough about it to treat it. And I don't know what else to ask of the AEF. They need to notice it and deal with it.
Are there any, and probably one of the final questions I'll ask you is just whether there are any issues that you think are urgent or need to be immediately addressed? Are there any ones that jump out to you as, look, that is a really urgent issue that we need to address, or is it just all of them?
It's urgency. We have too many people out there suffering, and we have too many organisations trying to help them.
Yep.
It's happening, and it needs to be rectified immediately. Immediately. Too many lives are going to be lost if we don't.
No, thank you, Ms.
They're
Weston.
suffering.
Commissioners, can I ask, do you have any questions for Ms. Weston?
Thank you. Commissioner Brown?
Thank you, Mrs. Weston. As always, I have lots of questions and I may not ask them all, but I just wanted to inquire a little bit more about the time when Bradley was being discharged from the Army. You talked about the charges and the sense that they were being increased and indeed trumped up, I think was your words. Do you have any sense why that was occurring?
I believe there's a mentality in the Army where these boys, they do as they're told. And they have to do as they're told. That's what happens in the Army. When they become disruptive or their behaviour changes, they get punished. And I believe this was my son's punishment.
But he was already being discharged at that time? So it was just, your sense was that it was an additional punishment?
I believe so. Absolutely.
Okay.
Well, I feel that they were being made harsher. Why would they be made harsher is my question. When he was being discharged anyway.
And it was a medical discharge, so your sense was Bradley didn't want to leave, or did he?
Bradley knew he was ill,
Right.
and I know that he could not continue because he knew he was ill and they knew he was ill and he was injured, so he couldn't function. And I believe when you're like that, you're probably a danger to his unit, or, what were you going to say, Gaia?
Probably tried to make an example of him.
So,
Yeah, I do believe that they were trying to make an example of Bradley.
right. And at the time that, just before he discharged, when Bradley stood in front of the vehicle, I think you said, and then a couple of days after his discharge, he made a suicide attempt.
In debriefing.
when you were told that he was not their responsibility? When you were told that he was not their responsibility? When you were told that he was not their responsibility, he was your responsibility, essentially?
I felt let down because I needed help and I didn't know where to turn to. I didn't even know how sick my son was at the time.
And then just a couple of other questions. I just wanted to understand, you mentioned that Bradley went to the hospital in Brisbane, but he was only there a couple of days and you got a phone call to come and pick him up. I think you said they couldn't handle him?
It was a doctor that called me and he said he has to come home, Bradley has to come home. He said, we can't have him here anymore.
Do you have a sense of why they couldn't have him there anymore?
At that time, Bradley also could manipulate situations. So maybe he made himself look well, or he was disruptive. Either way, I really don't know.
Right, okay. And sorry, just one last question then. You said it took 6 years for the gold card, for Bradley to get the gold card, and yet it's very clear that he had a medical discharge and he had diagnosis of PTSD at the time and clearly other physical health injuries. Do you have any sense of why 6 years? I mean, you mentioned there are lots of hurdles, but...
I have no idea. I'm angry that it happened and it took that long. I feel it should have been given sooner for the injuries that he had and that were accepted. But like I said, the goalposts kept being moved forward.
Okay, thank you.
Thank you. Commissioner Douglas?
Ms Weston, you say in your statement that Bradley would never speak to you about the events in Afghanistan and that you had no idea what he'd been through or why he was acting a certain way. And you agree that you didn't know what happened while he was on deployment?
No, I didn't.
And you say, my experience is that the idea of, this is paragraph 32, my experience is that the idea of mateship is very strong, and those in the army have a view that what they go through isn't to be shared outside of others in the army. Did you know or perceive anything to suggest whether he had anybody within the army whom he could share with or talk to about these issues?
I have, like I said, I have Brad's medical records, so I do believe he had made reports about these traumas in his reports. I have read them.
These are two psychologists.
Yes.
We've heard some suggestions about the desirability of something like a peer support system or a buddy system. Do you know whether he had anybody who might have been in that sort of role for him?
I really don't know, I'm sorry.
Okay, thanks.
Thank you, Mr Shiptua. Anything arising?
No, nothing, Commissioner, but perhaps just one final question for Ms Weston. Just, is there anything else that you'd like to say to the Commissioners here this morning?
I would like to say that I'm grateful to have been given the opportunity today to publicly verbalise the trauma of my son and our family that endured after Bradley faithfully served his country. Today I have only told a part of Bradley's story. My many years of pleas for help have come to this, and this is the last thing that I can do for my son. I will never have him back or hear his cheeky laugh. I'll never see his beautiful face again. But I can try and continue to fight to some kind of change. that may help his former colleagues and his future ADF comrades. The pathway to solutions to these issues is going to be very long and an arduous one, and that will need extremely passionate and devoted people to investigate and to execute. I don't envy the job of any of you at this point, but I pray that you will do the best for our country's bravest.
Thank you very much, Ms. Weston, for giving evidence on such a deeply personal topic here this morning. We really appreciate it. Thank you again.
Thank you.
Commissioners, that is the evidence of Ms. Weston. May she please be released from her summons.
Yes, we release you from the summons, but just before you go, I also want to reiterate what's been said. We are very grateful to you for coming forward. We're grateful to you, and we can only guess how hard it is to relive all those experiences. But this commission needs to hear these stories.
Yes.
And the public need to hear these stories. Thank you again. Yeah.
Thank you,
You're
Commissioner.
excused from the summons to appear, so you may head out. Thank you. Perhaps while she's doing that, if I can just mention to everyone here, these stories are difficult. They're difficult for people to relive, and they're difficult for people to listen to. If anybody is struggling with the sorts of things that we're hearing and the stories that we're hearing, there is counselling available to anyone who is struggling. If you make yourself known to any of the staff who are wearing orange lanyards, we have counsellors on hand, and they are available to assist anyone who may need to discuss the issues that they've heard who may have disturbed them. Thank you.
Commissioners, perhaps a brief adjournment until Danny Liversidge.
We'll have a short adjournment to reconvene shortly. Thank you.
All rise. The Royal Commission will now adjourn. Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Mr. Connor, good afternoon.
Thank you, Commissioner. I call Mr. Danny Liversidge.
Mr. Liversidge, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Operator, may I please ask that the redacted version of Mr. Liversidge's statement be displayed? It is document ID DLI.0001.0007_R. Operator, might you come to the next page, please? Commissioners, you'll see that this statement is dated on the front page 9 February 2022. And operator, might you come to page .0017? .0017, please. Mr. Liversidge, that's your signature?
Correct, it is.
And you signed that on the 10th of February
Correct.
this year?
Correct, that is.
This is the statement that you prepared for the Commission, Mr. Liversidge?
Correct, it is.
Apart from two areas of correction that you wish to make, is this statement, to the best of your knowledge and belief, true and correct?
It is.
And you wish to make amendments in due course to what appears in paragraphs 23 and paragraphs 64 and 65?
Yes, I do.
Commissioners, I attend to the redacted version of Mr. Liversidge's statement, being document ID DLI .00001.0007_R, together with its three annexures.
Thank you, Mr. Connor. So they're accepted and be allocated that exhibit number.
I also tender, on a confidential basis, the unredacted version of Mr. Liversidge's statement. And for the record, the document ID is DLI.0001.0001.0007. Commissioners, may I also at this point tender two other documents? The first is Defence Instructions, open bracket general, close bracket dash, homosexual behaviour in the Australian Defence Force. Operator, might you display DLI.quadruple 0.0001.0019. Commissioners, this is a so-called Defence Instruction General passed under Section 9 capital A of the Defence Act 1903. Might you display the centre of that page, operator? Commissioners, you'll see it's dated 4 November 1985. Might you go to the foot of the page, please, operator, and display that? It's a new instruction concerning homosexual behaviour in the Australian Defence Force. Might you go to the next page and display the heading of the next page and clause. Might you also proceed down the page, please, operator, and display the next two paragraphs? I'll leave that for a moment, Commissioners, to allow you to read that. Clauses 1 and 2 of the Defence Instructions General, and it goes under the label PERS 15.3. As I said, promulgated under Section 9 capital A of the Defence Act 1903. Might you go to the next, clause 3, please, under the heading AIM? Might you go to the heading Policy and clause 4? Might you go to the next heading, please, operator, Reasons for the Policy? And one will see there, Commissioners, 4 reasons referred to. Might you go next, operator, to the next heading, Administrative Action? And there are 3 clauses under that heading in this instrument.
That isn't in the hearing book yet, is it?
I'm not sure of the answer to that. The answer is no, Commissioner. My apologies for that. Now, this was a document that you provided, Mr. Liversidge, to the Commission along with your submission to the Royal Commission.
That is correct.
Operator, might you go to the next page, please? And might you display the first paragraph, please? Commissioners, I won't go through this in detail, but this is a 3.5-page document that concerns points relating to DIGG PRS 15-3, which was the last document that I took you to, Commissioners. May I go to the last page of this group of documents? It's .0025, please. And might you display the heading and the first 2 clauses, please, operator? This is also another instrument. It's DI bracket AF PRS 4-13, presumably also under Section 9A of the Defence Act 1903. And this is operative. One sees the date on page 2. At the foot of page 2, please, operator. This is issued 27 August 1980. And these are documents that you provided, Mr. Liversidge, to the Royal Commission in connection with your submission.
That is correct.
Mr. Liversidge, we now turn to you. Might you start telling us your story, your lived experience, where you started from and what happened to you?
Sure. So I guess my story starts back in a little country town where I was looking for opportunities, really, basically opportunities to have a career, get something outside of a small country town. And one day, one of those Defence Force recruitment vans pulled up in the main street. And, walking in there, it has, all these imagery of, helicopters and tanks and naval ships and people enacting different states of camaraderie with each other. It just looked, I took one look at it and went, that's for me. This is my ticket out of town. And this is what
little town is that one?
Dalesford, a little town of around 4,000 people back then, I think it was. I'm not quite sure exactly today how many people were in there. But it was a little quiet country town back then. It's not quite the tourist mecca that it is today, and or certainly not the the LGBTI community it has today. It has a very large LGBTI community. It's a nice little town, but it was a small town, and with very little employment opportunities. Much of we were going through the late 80s, going through the globalisation, and lots of manufacturing was disappearing from the town. So the Defence Force, to me, was an option. I spent a very short period of time in discussions with one of the personnel in the recruitment van. And
You went to school in the town?
Went to school in town, grew up,
You worked for a period after, you left school in year 10?
Left school and worked in a period of manual labouring jobs, basically constructing the town sewer. So, everyone can thank me for their toilet. So that was part of my role there until the defence van arrived.
And in 1988, a van rolled into town?
Yep, and it was just, to me, it was a vision of escape, to be honest, of a little country town. But it was also a vision of a career, where options of having a career were very limited in the town. But the defence, to me, was a genuine career option that I wanted to take up, and I signed up on the spot. It didn't take much convincing.
And you were having conversations with the people who arrived in the van, defence people?
Yes, correct, and having chats to them about the different types of careers, what type of things to sign up. I signed up to be a radio technician in the Air Force, which was a 6-year commitment. That was backed with, I think, around 2 years of training, so I saw it as a way of gaining technical skills and being able to learn something as well. It was a bit like an apprenticeship, not quite an apprenticeship, but a bit like an apprenticeship, where you underwent 2 years of training before being then rostered into a course. That changed down the track, though. That didn't quite pan out for me, but there was a reason for that.
And you moved out of Dalesford and you went for 6 months training at the RAF-based Elizabeth
in Adelaide.
In Adelaide.
Adelaide, yes, an outer suburb. So that training was challenging, not to say the least, but it certainly taught you a lot of discipline. And I actually thrived in that environment, to be honest. I actually excelled at the whole training component. I mean, those training is about breaking you, basically, to make sure, and retraining you in their way and their ways of doing things. And I was a willing participant in that and was reasonably successful. Ended up with accolades in marching and rifle drill and so forth like that. I was seen to have successfully navigated that training and came out the other side and
I think you enlisted on the 17th of November 1988,
Yes.
and then this image here is
That would have been pretty much at the end of the training on my parade, not long after the parade, marching out, where you march out after successfully completing training in front of your family and everyone gets invited to attend the final march out ceremony.
And is this the march out ceremony at the RAF base in Elizabeth? Is that
Correct.
Yeah,
Correct.
after 6 months of...
Yes, correct.
And your family, they came to...
Yeah, I had family, friends, a lot of friends from Daylesford came over that day to see me graduate from basic training, and they, I had friends, family, and about 3 or 4 friends all drove over from Daylesford to Adelaide, which is in Victoria.
It's a few hundred kilometres, isn't it?
It's a bit of a hike, but they all came and got hotel rooms and so forth to see me. My dad was very proud of me. He was very proud of me joining, and he was very proud to be there that day, as was my whole family and friends, to see me graduate.
And after you graduated as a leading aircraft manned Liversidge, and that was your title?
Yes, LAC, Liversidge. Yep.
LAC Liversidge.
Yeah, leading aircraftsman, Liversidge.
And what happened then? You changed where you were working within RAF?
So upon completing the basic training, I was then sent to RAF Base Williams in Laverton, where I was then to undertake the RadTech training that I had signed up for 6 years.
And Laverton is in Victoria.
Correct.
It's about 23k or so west of Melbourne.
Yep.
And it was established in the 1920s, I think, as a...
Yeah, it's been there a long time. I'm not sure it's there today, but I think it's basically been sold off. Yeah.
Now, tell us about... So, July 89, you're posted to Laverton. What area are you working in? Tell us about that period.
Yeah, so that period of time I was living on base. I was sent to RadTech training. I was undertaking RadTech training, which is radio technician, for those that don't know what RadTech is. And radio technicians worked on radar, communications, those type of things. I unfortunately, about 6 months into the course of that time, my grandparents were involved in a very serious accident, and my grandfather unfortunately passed away, and my grandmother was seriously injured. And I was rushed home under this circumstance and spent several weeks, going through mourning and so forth at that stage, which unfortunately put me on the back foot with my course. By that stage, the course had moved forward by nearly a month, and by the time I'd got back and was in the headspace to be able to pick up my training again, they had decided that it wasn't possible for me to catch up at this stage. And they suggested that I remuster to a new role as a result of that lag in that training.
Did you really want to leave the RadTech?
Look, it wasn't the ideal situation. I mean, I'd signed up to get the skills that was going to present, but there wasn't, unfortunately, there just wasn't a way to catch up that month. The whole thing moves forward very fast. And I guess it's not like a university or education where you might have side support to try and catch up. You're either there or you're not. And I wasn't there for a month, and that was a month of training that they couldn't see me making up. So
How many in your little RadTech training group were there?
it was a lot of people I went through basic training with. So there was about 12 people in this training course that I was in.
And then you were re-enrolled, as it were, in another...
Remustered. So
that's an expression, is it, that's
yes,
regularly used?
Yes. So I was given an opportunity of being a chef or a chef assistant in the cook. They're always looking for chefs in the forces. They offered me gardening, or they offered me transport. And I decided, after looking at the 3 options, that working transport section, where I would learn skills that I felt would be very useful to me, would be beneficial. So I selected transport.
And Tell us something about how you experienced transport and how you really enjoyed that.
Oh, I absolutely loved it. When I got there, it was just, to me, transport was just one big adventure. I was literally, one day, after going through training and learning to getting your truck driver's license, heavy vehicle license, and bus license and stuff like that. I was soon, carting officer cadets off to training into the Grampians, where they were doing orienteering, mountain climbing, rock climbing, bivouac, bush camping, sort of stuff. So to me, being the transport driver, I got to experience all the things that the officers in training were experiencing by just default by being there. And of course, they would, rather than stand around, they said, "Do you want to participate? Do you want to climb the rock? Do you want to do this?" And it was one big adventure. Like, working in transport was one big adventure.
And there came a time when one of your friends who was operating the switchboard heard something. What happened?
Yeah, well, I'd been working for about probably over a year, would have been over a year, 18 months in transport, and everything had been going really well. I had gained a nickname by that stage as the 20-year man, because everyone could see that I was committed to my job.
What does it really mean, 20-year man? What's that about?
Well, 20 back then, you only had to do 20 years and you could then retire on your pension. You were then eligible for a military pension. So it would have meant that at the age of 42, I could have retired on a pension. So my goal and career aspirations was to be the 20-year man who'd done his 20 years and got his pension. And it was so obvious to everyone that I was the committed airman that they nicknamed me the 20-year man in the actual department, in my transport section. So everyone just called me the 20-year man every time they wanted to speak to me. 20-year man over here.
20-year man, go do this. Or...
Go do this. Yeah. So literally, that was the level of commitment I demonstrated. So things have been going well. When just referring back to the switchboard, a friend of mine was on the switchboard, and he received a complaint from a woman. To this day, I don't know who that woman was, saying she wanted to make a complaint about me. Now, rightly or wrongly, he fobbed her off, looking after me, and then contacted me. He said, "Look, someone's trying to make a complaint about you. I don't know who it was. She didn't say what it was about, but she seemed pretty keen to want to get the complaint, so I reckon she might call back." So he gave me a heads up that something was up.
And you had no idea what that was about?
None. I had no idea. I hadn't. I'd never been in trouble. I'd never done drugs. I wasn't a drinker. There was nothing in my head at that stage that could have that alerted to me as to what there was a problem here.
And all the people within the transport section, that you were getting on with all of them?
Absolutely. I was. I mean, everyone loved me because a lot of people were married and in the section and had partners, and they didn't want to do the long trips away 2 or 3 weeks at a time away. So I used to, being single, I used to volunteer for all of that. So they saw my commitment as a benefit to them as well. So I got along with everyone. Everyone really, liked me.
And your section leader?
Yes, he would often refer to me as one of his best troops himself. So there was nothing from a military point of view I could see that I've done wrong that would engage someone to make a complaint.
And what then emerged? What happened?
Well, it was about 2 weeks later, my flight lieutenant of the transport section came to me and he said, "Danny, I've been asked to present you for a military interview." And he said, "I've never been asked to do that. And he said, "What's going on?" And he asked me what was going on. He himself had not been told the purpose of this interview. And I said to him, I don't know. But suddenly in my head, I've got the thought of, gee, my mates told me someone's made a complaint. 2 weeks later, now I've been asked to present for an interview. So suddenly things are starting to close in on me and I'm going, shit, something serious is going on here. But I still at that time had not twigged what it was really about. Because I had no reason to believe that I was doing anything wrong. So,
you're working away in the transport section there, and
yeah.
What happened? How did it
They told me that I should have representation on the day, legal representation. And I was given basically, I think from memory, it was three to 5 days notice of this event that I was going to be marched to. But they wouldn't tell me as to why I needed legal representation. So there was no telling me that what the meeting was about. There was no heads up to the topic that was going to be discussed. My flight lieutenant in my section didn't know either, and he was desperately making phone calls. He said, you know, you're my best trip, I'm not going to lose you. What have you done? So he's making phone calls trying to find out what this military police interview is about. He couldn't get any answers, so, you know, and he's just said to me, I've been told to tell you to bring legal representation. Now, I was 23 at the time, and being told you need legal representation at a meeting that you don't know what the topic or why you're being called for, and then being told to have that meeting, it's like, who was I going to call? And who would represent me without knowing what the representation is for? So I felt very unprepared for this meeting.
Did you have some funds to go and find someone?
No.
Did you know anyone with any legal connection?
No, I'm 23, no. I've never been in trouble. I've never had a reason for a lawyer. I wouldn't have known anyone in those circles. And yeah, no.
Were you offered any legal representation?
I was told that the Catholic Padre would be there to represent me if I couldn't find legal representation, but I turned that down.
They didn't offer you any legal representation?
No. They offered me the Catholic Padre.
Now, on the day that you had the meeting, tell us about, before you get to the meeting, what's happening?
Formalities required me to be marched there from transport, so my flight attendant was asked to march me, formally march me to the interview room where I was going to be interviewed. On that march...
Just tell me about the march. What's that like? What are you...
transport was a fair way from the thing, so we're talking a good over 1 kilometre on the base distance between transport and where the interview room was. So it was a fairly long walk where you're formally marching and feeling, and you know, to be honest, I was feeling isolated. You know, I don't know what the meeting's about. I know it's serious. The flight lieutenant's telling me he's never had to do this before in his career, and in that time he kept saying, "Are you okay?" And of course I wasn't okay. I was starting to become a bit of a mess because I don't know what all this trouble's about. And he kept saying, "I don't want to lose you. I know people. Tell me what you've done. You must know." And he said, "I can make some phone calls." And I said to him, "I honestly do not know." So he was as upset as I was that this was happening.
So you're marched publicly, are you, down...
Within the base grounds, but yes, publicly there.
Does that happen regularly, that one...
Well, he said he'd never been asked to do that before in his service career, and he was shocked that he was being asked to do it now.
And he'd been told to march you there, had he?
March me there, correct.
And
Formally march me there.
Are you, when you say march, are you walking behind him, or what's happening?
No, I'm walking in front of him, he's walking behind, and I'm formally marching.
And you're walking past other people, I imagine?
Correct, yes. Whoever was around at the time.
Now, you come to a place and tell us about that place where you come to.
So we arrived at this interview room, and I was entered into the room, and there was 2 military police personnel sitting at a desk. The base commander was in attendance, and obviously my flight lieutenant was behind me. And as I walked in, obviously, you know, you are required to salute to superior officers, which I did. So I undertook the formal requirements of meeting that person. And then I was told to sit down at the desk on the other side of the 2 military police officers.
So on one side of the table there's 2 military police
Yes,
officers, And there's two other people in the room?
Yes, so there's the Air Force commander and my flight lieutenant was asked to stay and observe in the rear. So I was sat at one side, there was the two military police officers. The base commander was in my line of vision to my left, and my flight commander was in my line of vision to my right.
So 4 people on one side of the room and you on the other?
And 23-year-old me on the other side of the table, yes.
Now, did they ask you whether anything about legal representation?
Yes, they asked have I had legal representation, which I said no. I reminded them I had neither the time, the resources, or the understanding to be able to get that legal representation. And they asked me to sign a legal representation waiver.
And you signed that document?
I signed it.
Now, what next occurred?
The next was quite the shock because suddenly I knew what it was about. A photograph was placed in front of me of an LGBTI bar in Paran, and I was asked what type of people frequent this bar. And that was like the old shit moment. Oh, sorry.
That's fine. You felt like that.
That was the oh shit moment. It was like, this is about my sexuality. And I was in shock. I was in shock from that first photo. That first photograph had me absolutely reeling in my head as to, my God, this is about me going to gay bars. And I was shocked. I was shocked that that's what it was about. And they then had a series of dates and times that they had known that I'd gone to those gay bars. And they put down further photos of the Peel Hotel, which was another one in Collingwood that I was attending at that time.
What was the name of that one?
The Peel Hotel.
Hotel.
Yeah, Peel Hotel in Collingwood. So they had photographs of the places I was attending and they had dates and times. And I suddenly realised that I had been under some type of surveillance and that my movements had been tracked and had worked out, obviously, my movements had been tracked in that 2 weeks since that complaint had been made, that I had been put under some type of surveillance.
Did they tell you anything about the surveillance?
No, they didn't tell me anything about it other than to show the photographs and provide dates and times that they had observed me attending these places.
And they had a sheet of paper, did they, with dates and times on it?
Dates and times, correct.
And they put that in front of you?
Correct.
And they proceeded to question you?
Yes, I was basically what I would consider, I know Yvonne, who's my support person today, presented yesterday, described as an interrogation, and that's what I classify as begun the interrogation, was that opening line of questioning. They asked over 100 questions over that period of time. I think it was about 2 hours that I was in this meeting. They asked again about the type of company I kept.
When you're saying they asked, there's one military policeman asking the questions, is there?
Yes. So there's one person asking the questions and the second military officer was typing up on a typewriter my answers to that. So the questions they were asked was about the company I kept, about what type of people attend these types of places, what type of company was I keeping? Was I keeping company with these people? And eventually the questioning went on and got down to quite private things that I never thought anyone would be asking me, down to a level about had I had sex with other men before? And how many times? I clearly remember they asked how many times I'd had sex with men, and I was getting increasingly, to be honest, I just wanted to crawl under a rock and die. That's how I felt at the time. I just didn't want to be there, and this was humiliating and shaming. It was shaming and humiliating questioning they were asking about deeply personal things that, things that I was still working out for myself. I wasn't ready for this label of homosexual. Eventually their questioning got down to, LAC Liversidge, are you a homosexual? And I was forced to answer for the very first time. I don't think I'd even call myself a homosexual at that stage. It wasn't a tag I was using on myself. But they had forced me now to, for the very first time, say, and it was the very first time I ever said it out loud, yes, I believe I'm a homosexual. And that was just, you know, as a young person still trying to work out where you fit in the world and where your sexuality on the spectrum sits. You know, my sexuality wasn't as black and white as it is today. It was very grey in those days, and they forced me to put a tag on myself, which I wasn't prepared at that stage to put that tag on myself. But they made me put that tag on myself because they had the evidence of me going to gay bars. So
Now, that took a period of time, this interrogation.
yes, it did. And there was lots of questions. Once I admitted that I was a homosexual, they then went through the process of trying to identify others with questioning along the lines, you must know others. Who on this base do you know is also a homosexual? And so the interrogation got particularly more... Interrogation started out seemingly quite matter-of-fact questioning, but when it started to get to the point of them wanting to find others, it became far more aggressive. And that's when I felt I was actually being bullied into trying to answer these questions, because it was, who do you know? You must know someone. And there's like banging on the table and all this sort of nonsense. And I'm sitting there terrified, absolutely terrified. I've been humiliated. I'm feeling absolutely ashamed of myself. I hate myself for this aspect of myself that I've just been forced to put a tag on by someone else sitting on a table with 4 people. And the hardest part for me was I really admired and respected my flight lieutenant of that section, and to have him sitting in that room listening to me have to talk about how many times I've had sex with men was humiliating to me. Humiliating. And yeah, it's had a huge impact, and it got worse. And it got worse from there in. Didn't get better. They by the time that we got to the interview and the there you have it question, are you homosexual, and answer that, and they'd then gone through, and I honestly couldn't give them names because I didn't know anyone on base. I was very not conscious of any other person on base who was homosexual. I'd certainly never met anyone out in the few times I'd been to the bars prior to that. And I'd probably been only going to those bars for 6 months since I'd gone to Melbourne. I certainly hadn't experienced any type of being in LGBTI safe places, which they were back in those days. Those bars and clubs were safe places for LGBTI people. We were living in an era of discrimination, and to think that they had followed me to those safe places, I suddenly realised if you're a military person in LGBTI, they were no longer your safe places, because here they were following you to them. So it was a whole range of feelings and emotions I was going through at that time. There was not just the shame and humiliation I was feeling about myself. It was the fact that the world that I had started to explore and accept changed that day. It didn't seem safe anymore. It changed. And yeah, and eventually it got down to the, you know, they wrapped up the interview with the term, AC Liversidge, are you aware that homosexuality is incompatible with military service? And I thought to myself, incompatible? In what way? Incompatibility was never explained to me what they meant by that term. They just said I was incompatible. And that was funny because my flight lieutenant thought I was his best troop, so he didn't think I was incompatible. But here were these strangers sitting across a table telling me that I was now incompatible with military service.
Now, it then turned to you being put various options.
Yes.
3 options. What were they?
They were blackmail. That's what they were, blackmail. So they presented 3 exit strategies for me. All of them were traumatic, but there was one that was least traumatic, and that was the one they continually pushed me to take. So they said that if I didn't accept to leave of my own accord, then I will be dishonourably discharged, my records will be marked that I was discharged for being a homosexual, and my training records would be withheld from my final exit papers. So they were suggesting that they would out me and ruin any other chances of re-employment if I didn't agree to leave on my own accord. So that was option 2.
So that's refusing to provide you with your training records.
Correct.
What do you think about that?
I'm still in shock from the original photograph of the market being put down. So I guess it's for me, it was, here's my career, the 20-year man, and they effectively told the 20-year man that your career is over, and here are your 3 terrible options. One's not so bad, one's really bad, and one's just the go nowhere option. And threatening dishonourable discharge and withholding of the records was apparently their sympathetic way of dealing with the homosexual in the Air Force. The other option they provided was that should I try to fight the dishonourable discharge and was somehow successful in that endeavour, that my records would be marked that I was at least investigated as a homosexual and that my career would go nowhere. I would never be offered a promotion again. So a stalled career or a dishonourable discharge, or leave quietly of your own accord right now, and they wanted a decision there and then. While I was under much duress and much pressure, they wanted an answer straight away. And so I selected the least traumatic option of the day, which was to go quietly.
Commissioners, paragraphs 34, 35 and 36 of Mr Livicich's statement refer to the 3 options that Mr Livicich was presented with on that day. And you took a particular option, as you put it, to go quietly, as it were.
Go quietly, yes.
What did that mean for you?
It meant the end of my career. Everything I had been working for, it meant to me that no matter how much I went in every day to do the job to the best of my ability, it was worthless, because my job performance wasn't the first criteria of the Air Force. Heterosexuality was the first criteria, and I didn't make the first criteria. So therefore, I was already incompatible from that point of view. It just meant that, despite the fact that I was a loyal, committed, enthusiastic airman, going in every day to do the job to the best of his ability, was worth nothing at that point in time. And those words were even reflected in their discharge unit report, where they acknowledged those exact words that I've said.
And Commissioners, for the record, the minute of this interrogation, as it were, is at DLI.quadruple0.0001.001. Now, what happened? The meeting ends.
Yep.
Are you given any instructions about what you can and can't do?
Yep. So at that point in time, I was told, having accepted that I would now be going through a discharge process, I was told to return to work and continue on as normal, which was pretty difficult given what I'd just been through, and that they would be telling me the discharge process. So obviously there was a medical examination, there was a psych assessment, there was appointments with the storeroom to return everything that you were given at the start. You were given a kit, and you had to return all the kit, including all your uniforms you're wearing. So that process took around, I believe, 2 weeks from the meeting. But I was pretty damaged by that stage and absolutely struggling to go into work every day and trying to keep it a secret from my colleagues, because now I'm just completely humiliated and ashamed And the last thing I wanted was for people to know about this, that this was what I was going through, so I didn't talk it to anyone. I don't...
You were directed not to talk to anyone?
Yes.
As well?
Yeah, so at work I just wasn't talking to anyone. And then after a period of going through that process, I was living on base, so I lived on base. So the process then called, after handing back, that I was to be escorted. I was given 24 hours notice to pack my car and that I would be leaving the base the following day. So I was given leave from work to go and pack my car with all my worldly possessions in that one room that I lived on in base. I wasn't allowed to say goodbye to my colleagues or my fellow people who lived next door in the dorm with me.
You wanted to say goodbye to them?
Of course I did. I'd made friends. I had friends in there, and many people in the transport section had become my friends, and I was told I wasn't allowed to say that I was leaving or to mention to them what happened. I was just told to prepare myself to pack my bags, pack my car, and I'll be leaving the following day.
And you didn't say goodbye to anyone?
No, I didn't speak to anyone.
And other people are allowed to leave with some of the insignia, as it were, of their service.
Correct. I was made to hand everything back. So despite the fact that I at this stage had completed almost 3 years of service, I was not. Most people, upon exiting of you finish your time and you honourably discharge at the end of your service, you're allowed to wear the parade uniform with which you were issued at the start. I was not allowed to hold on to that parade uniform. I was advised that everything had to go back. So even though supposedly I was getting an honourable discharge, I wasn't allowed to keep a single remnant of an artefact from my military service. Everything was taken off me.
And
even the work clothes I'd been wearing the day before were removed. So
now, the RAF didn't provide you with any assistance at all?
There was no transition. It was the process that I was following was purely the process from the Air Force's side of what they needed me to do in order to discharge me. There was no transition support whatsoever. There was no one asked, did I have somewhere to go, which I didn't. There was nothing. It was just about what their process was from their end. There wasn't a single support reach out for me whatsoever.
And so what happened the next few days?
So the day came for me to leave the base. My car had already been packed. The military police truck, that was a four-wheel drive, came to my dorm. They knocked on my door. We went down to the car and they escorted me off the base and shut the gate. And it wasn't, because I'd been in shock, I hadn't really thought about next steps. That wasn't on my radar because I was so busy still dealing with what was going on. I hadn't thought about it. So I pulled up several hundred metres from the gates because I suddenly had become aware that I had nowhere to go. I lived on base, I'd just lost my home. So I effectively now was homeless. My worldly possessions were packed in the car around me, and I then sat in the car for a minute trying to think what I was going to do. There were reasons I couldn't go home at that time. I wasn't out to my family. I wasn't prepared to tell them that I'd been exited because I was a homosexual. Not that I believe they would have had a real issue with that anyway, but I just wasn't ready for that. As I said, I hadn't put that label on myself yet before the Air Force did. So I was sitting in my car and I back then there was no mobile phones, no email. So if you wanted to speak to someone, you rang on the landline. That's how you spoke to people, it was on the landline. So I found a phone booth, several blocks away from the base, there was a phone box, and I started calling the only person. I had a number from someone that I'd met in a bar. I didn't know anyone else outside the Air Force other than this one person who gave me his number once, and I couldn't say I really knowed him that well other than having hung out for drinks several times at a bar with him. And he was the only person I could call to try and find somewhere to stay that night. But unfortunately, he didn't pick up the phone for 2 days.
And you slept in your car for a couple of
I
days?
slept in my car for 2 days.
Now, can you tell us about the period of time that followed? You've been so-called honourably discharged.
Yeah.
How did you feel?
Sorry, Mr. Connor. Can I just say one thing about that period in that car, which I feel is very relevant, is that at that point in time, I'd gone from being a loyal, committed, enthusiastic member of the Air Force to jobless, unemployed, homeless, living in my car, surrounded by possessions in the space of less than 2 weeks. That was a lot for a 23-year-old to be dealing with at that point in time, that your whole career's gone up in smoke in 2 weeks and you're now living in your car on the side of a street. That's what they did to me.
Thank you, Mr. Liversidge.
And every time over those 2-day periods that someone didn't answer their phone, I felt lonelier, more isolated, and to be honest, suicidal. There's 2 ways it could have gone if no one had picked up that phone. And then one of them would have ended up with me not being here today.
Fortunately, your acquaintance picked up the phone.
Picked up the phone and gave me somewhere to live. Yeah.
And then the years and the years roll by, as it were.
Yeah.
Tell us a little bit about the years and the years until you come to probably 2018 or thereabouts, is it?
Yeah, 2016.
Oh, 2016, my apologies,
2016,
yes.
that's it. So the following years immediately after that were ones issues. I had a lot of issues around self-worth, obviously. I hated myself for quite a long time and had decided not to tell my family what had happened because I was ashamed of what had happened and I didn't want to have them disappointed with what had occurred. My dad was very proud of me being in the Air Force, so having to explain to them at short notice how the 20-year man was now not in the Air Force was a challenge. So I hid it from them and just told them that an opportunity to discharge came up and I took the opportunity without going into much detail. So that was a secret about that effect that I kept locked away for a very long time. Obviously, a few immediate people that I'd met, my acquaintance who let me stay, I told him, and I certainly my inner circle of friends had known what happened. But outside of that, I kept it pretty much under lock and key as to what had occurred and got on with life as best I could. But unfortunately, I probably was a bit of a wounded person by this stage, and unfortunately there are people and opportunists out there who kind of see wounded people and wanted to and find are easy to take advantage of. So I ended up going through a number of relationships over the years that were not based on mutual values or anything like that. It was based on me just accepting someone into my life because they liked me, because I didn't like myself. So if they liked me, they were good enough to go out with. And unfortunately, that set me up for a whole range of failed relationships as a result of that, because a lot of people just saw opportunity to manipulate me into ways and to get things out of it. And, I've helped a number of ex-partners into housing, I can tell you that, which I wouldn't have done today if I was, more self-aware and more less loathing of myself.
And before you went into RAF, and for those early, the period whilst you're in RAF, you had none of this sense of what you've just described then, this self-loathing, as it were?
They destroyed my confidence. As a young man, they already destroyed it. They put labels of unemployed, homeless, homosexual, incompatible. I went into the service with aspirations of a 20-year career, and I left tagged with a whole bunch of labels I never even had heard of before.
In terms of corrections to the transcript, sorry, to the Mr. Livisich's statement, I understand in paragraph 23 you wish to change the third sentence with 5 people of superior rank to it's 4 people.
4 people, correct.
Now we come to paragraph 62 and that section of your statement. Now this is May, perhaps even a date, 24 May 2016. It's a Tuesday, and it's the afternoon of this Tuesday. What happened?
I had previously been watching the news where Premier Daniel Andrews of Victoria was giving a public address around him was going to cancel all the convictions of gay men who'd been involved or had been caught in this entrapment police process where police were entrapping homosexuals into acts of, then telling them that they're being inappropriate in public. But the police were actually engaged in encouraging the behaviour so that they could then charge them with the behaviour. So police were undercover trying to draw people into committing an act, and then they were charging them and having criminal convictions of them. It was called entrapment. Daniel Andrews had recognised that entrapment as being a discriminatory practice by police at that time, and he did a state apology to those people and quashed their convictions as a result of the belief that it was a discriminatory practice that shouldn't have occurred in the first place. And I was inspired by this, to hear Daniel Andrews apologising and wiping the convictions of these people because they were discriminatory and recognised discriminatory, prompted me to finally talk about in 2016 my experience. And I wrote a very sort of lengthy Facebook post acknowledging Daniel Andrews' apology and saying this has now inspired me to tell my story of discrimination in an institution such as the Air Force and what had happened to me. And it was the first time I'd publicly ever said anything. And it was the first time my family were to know of it. In fact, I signed off on that thing that my 27-year, this is the first my family will hear of it, my 27-year secret is finally out. And that was 2016, that I finally admitted to my family what had happened.
Commissioners, at 2 p.m. On Tuesday the 24th of May 2016, a rainbow flag was flown over the top of the Parliament House in recognition of the state apology, and there was a state apology given at that time. Daniel and Premier Dan, I move that this House apologise for laws that criminalised homosexuality in this state, laws which validated hateful views, ruined people's lives and forced generations of Victorians to suffer in fear, silence and isolation. The Premier said, to his knowledge, no jurisdiction in the world has ever offered a full and formal apology for laws like these. The Premier went on to say, so please let these words rest forever in our records. On behalf of the Parliament, the Government and the people of Victoria, for the laws we passed and the lives we ruined and the stance we set, we are so sorry, humbly, deeply sorry. The then opposition leader Matthew Guy said it was a shameful and distressing chapter in Victoria's history. Went on to say, after decriminalising homosexuality in 1980, after expunging criminal convictions relating to homosexuality in 2014, we now as a Parliament apologise to the victims of policies of intolerance, repression that resulted in outcasting, depression and sadly even suicide. He went on to say, it's about time and it is right. Now, on that very day, Commissioners, may I refer you to Annexure 3, if that might be displayed, it is DLI.000.001.004. Might you display the top half of that, please, operator? So on that same day, it appears, Mr. Liversidge.
It prompted me to want to share my story when I heard that there was a sympathetic ear in the government to these issues. I felt the courage to actually go and write this post and tell people in my broader family and friendship circle what had happened to me 27 years prior, because I'd been holding it on a secret for 27 years, and I just felt I just could not hold that secret anymore after hearing it. And so it prompted me to write this post. And it was the first time my family had heard of what happened to me at that time. And they were horrified, as were all my friends were horrified. Every single person I talked out to, every single person who read that story was absolutely horrified that this was something that could happen to me so young, and it did.
You then, shortly thereafter, wrote to the Premier.
I did. I wrote to Daniel Andrews to thank him for his support of LGBTI people. I felt so strongly about that statement that he gave that I wanted him to know that I appreciated his support. And I also wanted to alert him that this wasn't the only type of discrimination that LGBTI people are experiencing over the years. And I went on to tell him my story of what happened to me at that time. And I wasn't expecting a letter back. I got a letter back and was shocked to see that he said sorry for that I was unable to continue and things. He told me that he was fully aware that there are many other avenues that we've got a long way to go yet before the injustices were righted. And he thanked me for his support, and I thanked and wished me well. But it was the first time someone in authority had acknowledged my personal story, and that was, to be honest, I would say was the start of the healing for me, when I started to openly start talking about this for the very first time, and it led me down a path of meeting other people who have continued to support me in my recovery.
Commissioners, the Premier's letter back to Mr. Liversidge is Annexure 2 to Mr. Liversidge's statement. Now, Mr. Liversidge, paragraphs 64 and 65 require adjustment.
Yes.
The relevant sequence of events is as you've just relayed,
Correct.
which was the state apology, the Victorian state apology, on the 24th of May 2016. Your Facebook post, as it were,
Yep.
also on the 26th of May 2016. And it was the state apology that inspired your Facebook enabled,
Correct.
allowed you to feel.
Confident enough to now talk about this while it was topical.
You then wrote to the Premier, and the Premier responded.
Correct.
So paragraphs 64 and 65 need to be adjusted in accordance with Mr. Liversidge's evidence just given. Mr. Liversidge, how did you come, what then happened? After you posted the Facebook page, you came in contact with Mr. Noah Reisman, or is it Professor Noah Reisman?
Professor Noah Reisman.
Professor Noah Reisman. And you also had the privilege of meeting your support person today, Ms. Yvonne
Partner in crime.
Yvonne Sillett.
Correct. From that post, and obviously I started to talk about it, word had started to filter out to a lot of friends. I had a friend whose mother was a state MP. She reached out to contact me to talk about what had happened, and so I'd had a follow-up contact with another person within the Labor Party. I then was made aware of a study that was occurring. Professor Noah Risen was doing a study in 2018. I think it had been going for some time. I was coming at the very end of it, looking at, he's an historian at Australian Catholic University. I hope I'm allowed to use his name. And anyway, he was doing a study into LGBTI history in the military as an historian. And he asked if I would participate, and I agreed to participate. So it was a very long, it was an interview process. It went for several hours, talking about my experience of this again, while I shared my story and this light. And post that, he put me in touch. He said, do you know there's someone else in Dalesford with a similar story to yours, and you live not very far from each other?
In Dalesford?
In Dalesford. And
I thought you knew everyone in Dalesford.
Well, apparently not everyone. So he introduced me to Yvonne Sillett, who gave evidence yesterday. So, of course, Yvonne and I hightailed it for coffee and shared our stories, and started talking about how do we get what happened to us out into the media by this stage. How do we make people aware? Because it was obvious to us that not many people were really aware of these anti-LGBT policies, or to the extent that they were being implemented, or the variation in treatment you got depending on which service you're in and what time and place and all this sort of. The application of these policies, experiences were very different. And the more people we got to talk to out of this study, the more we realised that it wasn't just us. There's more people involved here, that there were unknown number of people who were treated in this manner. And we decided that we would create an association called the Discharged LGBTI Veterans Association to advocate on behalf of people like us who are still traumatised years down the track.
And that first word in the label for the organisation, discharged, what does that mean? What are you indicating?
Well, it means forcibly discharged. So we're an association of those who are forcibly discharged because of our sexuality. And forcibly means whether by coercion to quit, or whether by dishonourable discharge, or by, in the cases of Yvonne, downgrading of her job role to a point that she was then forced to leave. So, we're trying to reach out and touch base with people, because I realised that at that stage, I didn't know all the mental health support I was entitled to. So I had, up until 2016, had attempted several times to get mental health support through my own resources. And of course, being on very limited funds, it was very expensive to get support. And what would happen, I would get support over a number of weeks, and then I'd go broke, and then I'd have to drop that support off. So I tried to get my own support at the time. And it wasn't until I was introduced to Yvonne that Yvonne was a bit further down the path of being aware of all the resources were available to me. No one in the Department of Veteran Affairs had ever reached out to me to tell me.
Or Department of Defence, did they?
Defence, no, nothing ever. So I wasn't aware that I was entitled to what they call a white card, which gave me free mental health support. And it was Yvonne who told me that. And then through that, I was then, because I now had a white card with free mental health support, I didn't know I was entitled to a service badge. Remembering I'd handed everything back in 1990 and wasn't allowed to keep a thing, so I had no memory or no physical item that recognised my service.
Operator, might you display the photograph of Miss Sillett? Now, this is you.
Yes, this is me.
And Miss Sillett. And you're not wearing your medals on this particular day?
No, I'm not, no.
Tell us something about that.
To be honest, despite applying for the service medal that I was entitled to, I am still uncomfortable wearing it because my memory of my service is not pleasant. So it's very difficult for me to have pride in that medal, even though I should have pride in that medal, but I don't. because it represents a shaming and humiliating and degrading experience in my life, and I think that's a shame, but that's how I feel. So it's difficult for me to wear that medal.
So we come as many, more than 2 decades pass
Yes.
before you are able to get the medals at all.
And then I didn't want to wear it when I got it.
Now, what I believe you have some views about what should have happened to you, as it were, accepting that you've been so-called honourably discharged.
Yeah.
What should have happened, do you think, after that?
Well, first of all, 12 months later, the policy changed from me being suddenly incompatible to now I was compatible. And, you know, to be honest, if the Air Force had reached out to me and said, we understand we would discharge you under this policy, we want you to know that policy has now changed, we would like to welcome you back, I would have been back there in a flash, without a doubt. Despite what they did to me, I would have went back because that was the career that I wanted.
And become a 20-year man.
And become the 20-year man that I was meant to be. And so that could have happened. I also don't understand why it took a third person unassociated with the Department of Defence to tell me what my entitlements were as an ex-veteran. I would have thought that as mental health support became available, that some type of outreach program would have begun to contact all veterans to say, hey, by the way, do you know that your card now entitles you to free mental health support? I mean, that type of check-in, you know, if I had that years ago when that first became available, rather than finding out in 2018, 30 years after the event, that I actually could get mental health support, I could have changed a lot of negative things that happened in my life. I would have had the opportunity to address that dark secret I was keeping locked away. But I wasn't given that. I had to find that out myself. And I don't understand why they wouldn't have had some sort of outreach program supporting veterans with what services are available to them.
Commissioners, in that regard, paragraph 75 of Mr. Livisich's statement, I believe I should have been contacted by the military and told about the support services now offered and should not have had to hear about it secondhand from someone else.
Yeah.
Now, Commissioners, I have no further questions unless Mr. Livisic would like to say something further.
There's nothing further you want to say, Mr. Livisic? No. Anything further you want to add in summing up?
Nothing further to say. Thank you.
Thank you.
Said it all. Yeah.
Thank you. Commissioner Brown?
Thank you, Mr. Livisic. I have a few questions. Firstly, you recounted the incident when your grandparents had the accident and your grandfather died, your grandmother was injured, and you had roughly a month, I think you said, off work?
Correct.
Did that? It seems from that brief account that you were supported by the Air Force at that time.
I wasn't. I was supported in absolutely having leave and allowed to go home and spend time with the family as they grieved. There was absolute support, but I certainly wasn't supported in the return of my course. I wasn't offered any additional tuition or opportunities to catch up. I was basically told I was now a month behind and that they saw that that was an impossible thing for me to catch up on. They had their timelines moving through and I was, you know, at the time I would consider myself forced into a career change.
Right, okay.
I was forced to, so I wouldn't call that support.
Okay. I was just trying to kind of understand whether there was a sense of emotional support there.
Oh, yes, absolutely. People understood the emotional support and certainly gave me time off in the middle of this course to attend both the funeral of my grandfather and, grieve with the family over that. And my grandmother was in hospital for over 6 months recovering from that accident. So it was a terrible accident and,
In contrast to that, when you had the interview and the discharge 2 weeks later, it doesn't sound from the account you've given that there was much sense of emotional support.
there was not a single effort made to understand how I was feeling, what was happening with me. Did I have somewhere to go? Did I have the funds? I exited with just that week's fortnight's pay and $600, which I'd been paid at that stage into the military pension. And I was refunded the pension amount plus my fortnightly pay, and the whole amount I think was around $1,500 to my name. So that's what I left with. There was no support, understanding, did I have somewhere to go? Do you have money to get a flat? Money to buy furniture? Nothing. It was leave quickly and as quietly as possible is what we would like you to do. It wasn't any sense of transitioning support for me at all. Hence the reason you end up sleeping in your car homeless on the side of the street.
And while you've been talking, I've been looking at that defence instruction, the PRS 15.3, which in part says that the instruction does not require the member to be discharged, but does require, this is talking about, requires the commanding officer to be aware of the sensitive nature of investigations into alleged homosexual conduct and handle it with sympathy, understanding and discretion. But it says the instruction does not require the member to be discharged, does require consideration to be given to discharge of the member. And it goes on to say an investigation would only be initiated should a homosexual either bring his homosexual preferences to the attention of his commanding officer or should his conduct be such that it was brought to the attention of his commanding officer. So I'm just curious, why, do you have any thoughts as to why, given your history of excellent performance?
I don't, to this day, I don't know who made that formal complaint about it. It had to have been someone who had obviously seen me in a gay bar, and it had to be someone who was obviously aware of the fact that you couldn't be homosexual, so homosexuality was incompatible. So it was a malicious complaint, and to this day, the person, I think they say themselves that it was an anonymous complaint. The person didn't even put their name to it, so there was no way for me to track back to who the person was.
But you very clearly outlined how the application of that policy in your case directly led to you being suicidal.
Correct. So because a public complaint had been made, that was one of the, I think, reasons for discharge if it was brought to their attention. So a member of the public had brought it to their attention. So I think under that Policy Act, that is what I was discharged under, irrespective of the job I did. And that was, one of the, the words, if I was to read out in the unit report, a summary of what they thought of me at the time, and I just don't know where I'm going to find that. I don't want to hold you up.
Perhaps paragraphs 41 and 42 of your statement,
41 and 42.
You include extracts from the...
Okay, because I want to read that out because the reason I want to read it out was I only got this recently, this unit statement that talked to my discharge and to the reasons why. And in that, sorry, Mr. Connor, I can't find it in my statement. Is it up on the thing? Related to my question. So paragraph 41 Since his arrival on 26 July 1999, AC Liversidge has presented a personal young airman with a well-developed sense of responsibility and determination to carry out his mustering duties to the best of his ability. That's their words, describing me as they discharge me. And I find it incredible that they held me in such high regard but treated me in such appalling manner upon my discharge, even holding me in regard. Shit, what would happen if I was no good at my job? You know, here was really someone who was good at his job, and they recognised it, and yet it meant nothing. It didn't affect the way they treated me. In fact, they treated me abysmally upon my discharge, and without a care in the world. And they thought that of me, at least. I can't reconcile the two experiences.
Mr. Liversidge, you said the policy, the Defence Force policy changed the year after.
Yeah.
And you said you would have gone back had they asked. But how did you feel when you heard that?
When I heard that the policy had changed, it was one of, frustration. I think I found it is that if I just somehow went under the radar for another 12 months, none of this would have happened. None of it would have happened. You know, the don't ask, don't tell. Still not a great policy, by the way. It's one of like saying, you say nothing, we say nothing, we all get along, right? That's not really an appropriate policy either, by the way, but it was better than being hunted and kicked out. So it was a step forward, though I think it was still an atrocious policy. And, but still, I could have lived in the Air Force and continued on under that policy. So it was hugely disappointing to me that I'd missed it by that much. You know, I felt frustrated, elated for those now who could stay, but frustrated for myself that I'd missed them up by 12 months.
And just one final question. You described very eloquently how the apology from the Premier of Victoria was so significant and was the start of your healing process.
Correct, Commissioner, it was.
What would it mean to get an apology from the Defence Force?
It would be huge. It'd be recognition after 2 years now that they get what they were doing was wrong. And I think this is still missing from the narrative of these stories that we're telling here today, is any sense that they thought they were doing anything wrong, because they weren't, they were following policy, right? So they don't have a sense of doing it wrong, even though those policies now are well and truly debunked as being flawed policies, and hence the reason they're no longer there. That's why they're not there anymore, because they've been debunked. But it doesn't mean that they weren't wrong at that time. There are many reasons. We've given apologies over historical things many times for injustices that were committed on people because they were wrong. And I feel that the Department of Defence should give an apology in the same way for how we were wronged because of those policies. Because a lot of us were treated in a brutal and unsympathetic fashion, despite what the policy says to treat us in that certain way. But they didn't. They didn't take the sympathetic option. They took the brutal, get them out quietly, quickly as possible, without regard to those people.
Thank you.
Thank you.
Commissioner Daniels?
Yes. Thank you also, Mr. Liversidge. There's a couple of questions I wanted to ask. Going back to 1990, when you were being interrogated, were you aware of the policy that Mr. Connor put up on the screen in the first instance?
I wasn't aware of that. No, I'd never seen that policy at all. That was not something that was ever shown to me.
Were there ever any lectures about policies like that?
I think when you sign up at the time, there is a box that you tick to say that you aren't homosexual. So there is a box somewhere in the paperwork that you tick. But like I said, at the time, my sexuality was very grey. It wasn't black and white to me that I was considering myself at the age of 19 a homosexual. I was still wanting to explore that myself and come to my own determination. So I wouldn't say that it was black and white to me when I ticked that box. But yes, there is a box that says you're not homosexual.
Now, by that time, my understanding is that in Victoria, and I think probably most other states of Australia, apart perhaps from Tasmania, homosexuality was no longer an offence for homosexual
No.
behaviour. So was there any attempt, either during your interrogation or in any other explanation of the policy, to address that issue, that it wasn't illegal behaviour?
No. It was. I was made to feel that my sexuality was a negative thing that was not compatible with the military service, and that I should be quitting as quickly as possible.
Did you have a security clearance?
No, I didn't. I drove trucks. I don't think I was a threat to anybody.
Thank you.
I think it was 1980 that it was.
It came into force, according to Wikipedia,
Yeah.
in March 1981, passed in 1980 in Victoria.
Yes.
I think there was some residual offence referred to in that work of record of soliciting for immoral purposes, which continued until the late 1980s.
Thank you, Commissioner.
I haven't checked it with the statute.
Just one small minor matter.
You might want to wait until after I'm finished. So that's all right.
Of course,
You might as well do
my
matters
apologies.
arising at the
My
end. Okay, thank you.
Round of
Thanks, Mr. Cobb.
apologies.
No worries, no problem. Mr. Livingston, just one question. I just want to understand for my own benefit the procedural fairness or lack thereof that was afforded to you. So you went into the interview not knowing you were going to be interviewed?
No, I knew I was going to be interviewed. I did not know
But not
about
knowing
the
the
topic,
subject?
the
Yeah.
subject.
And
I
you
was
were not
told.
aware, obviously, of hadn't refreshed your memory about any rules or standard operating procedures or orders that existed in relation to this issue? You wouldn't have had a chance to read any of that, obviously.
No.
Okay.
No, I wasn't made aware. No, and I didn't have time to research what my options might even have been. It was.
And you didn't have access to legal representation, nor were you in a position, obviously, to have done anything about that because you didn't know what you were walking into?
No.
And you were you offered the opportunity to say, look, if you want to get lawyers, we can postpone this for a day or two?
No. It was acknowledged that I had arrived without legal representation, and therefore I was asked to sign a waiver form that I was being interviewed without representation.
Was that waiver asked of you to sign before or after the allegation was put to you?
Before.
Okay, thank you.
Yes.
Mr. Connor, sorry, any matters arising?
Just one, you didn't mention this in your oral evidence, but there was one act of kindness, as it were,
Oh, yes.
um,
Yes.
and that was from the military.
One of the military police officers, yes. At the end of the interview, one of the investigating military officers, after we had officially signed off, came up to me and apologised to what was happening to me. And I thought it was significant in that he said, I don't like what I'm doing. I'm doing it because it's my job, but I want you to know that I don't agree with it. And that was one of the military officers. So there was a sense of sympathy coming from one of the investigating officers about that. And I did make note in my statement that I felt that these anti-LGBT policies weren't just affecting those that they were targeting, it was affecting those that were being asked to implement those policies or investigate those people who, for whatever reason, ethically, morally, didn't agree with them as well. And I did say that I felt that that was another negative impact of these policies, was on those people who had to implement them.
Thank you very much, Mr. Liversidge.
No worries.
Mr. Livingston, I just, on behalf of the Commission and my fellow Commissioners, I just want to thank you for coming forward, for giving your evidence in the rational, calm way that you have today. We know it's not easy to talk about this stuff. We know it's difficult to relive bad experiences, and we're grateful to you for coming forward.
Thank you, Commissioners,
Thank
for
you.
listening. Thank you so much.
Commissioner, might Mr. Liversidge be released from any summons?
Yes, you're excused from the attendance notice.
Thank you very much.
Mr. Livingston.
Thank you.
Thank you, Commissioner.
I think we'll adjourn now for lunch and back at 2 o'clock.
2 p.m.
All rise. The Royal Commission will now adjourn for lunch. Royal Commission into Defence and Veteran Suicide is now in session. Please be seated.
Thank you, Mr. Connor.
Commissioner, I call the Honourable Jennifer Coate, AO, Mr Ian Freckleton, AO-QC, and Mr Hugh Dillon.
Thank you. Welcome. We appreciate you making the time, and we certainly appreciate you giving evidence today for the Commission.
The Honourable Jennifer Coate, AO, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Dr. Ian Freckleton, AO, QC, do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Hugh Dillon, do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Operator, might you display the Coronial system tender bundle, please? Commissioners, you'll see there 8 items listed. You'll see curriculum vitae and brief biographies. You'll see a paper, which is item number 5. It's a paper by the Honourable Jennifer Coate. It's given to the Australian Institute of Judicial Administration concerning family and domestic at the Family and Domestic Violence Conference, and the title of the paper is Family Violence Death Reviews in the Coroner's Process in Victoria. That paper was given in October 2009, and it'll come to be referred to later in the evidence that comes before the Commission. Commissioners, item 8 is a submission to the Royal Commission into Defence and Veteran Suicide by Mr Hugh Dillon, which also has valuable components within it.
Thank you, Mr. Connor. So those documents will be accepted as exhibits and assigned the next exhibit number as they appear on the list.
Thank you, Commissioner.
Thank you.
Ms Coate, in 1992 you were appointed as a magistrate in the Magistrates Court of Victoria.
Correct.
In 1995 you took up appointment as senior magistrate in the Children's Court of Victoria and
That's so.
also the position of Deputy Chief Magistrate in the Magistrates Court of Victoria.
Yes.
In June 2000, you were appointed as a judge of the County Court of Victoria and then as the first president of the Children's Court of Victoria.
Yes.
And whilst president of the Children's Court, you established what was known as the Children's Query Court.
Yes.
In 2006, you returned to the County Court of Victoria.
Yes.
In 2007, you were appointed State Coroner of Victoria, in a position you remained for about 5 years or so.
Yes.
Now, Commissioner Coate will come to this later, but the Coroners Act 2008 of Victoria is, we will see, a very significant piece of legislation, and you were involved in the reform process that led to that legislation.
Yes, that's so.
Now, as the Victorian State Coroner, you also oversaw the establishment of the Victorian Systematic Review of Family Violence Deaths in 2009, and that was within the Victoria Coronial system.
Yes,
And
that's
it's
so.
referred to in the paper that I referred to that's now before the Commissioners in evidence.
Correct.
You presented the first report of the Victorian Systemic Review of Family Violence Deaths in November 2012.
Correct.
In 2011, you conducted an inquest into the death of Mr. Tyler Jordan Cassidy, and in the course of that, writing your findings concerning that, you carried out an analysis of the law for coroners concerning suicide and proposed a formulation, as it were, of the question that might be asked. Is that broadly correct?
That's broadly correct, yes.
And you also, as Victorian State Coroner, worked with the Judicial College of Victoria to develop the Victorian Coroners Court Practice Handbook.
Correct.
In January 2013, you became a judge of the Family Court of Australia.
Correct.
You were released from that position to take up a position as a Royal Commissioner into the Royal Commission into Institutional Responses to Child Sexual Abuse.
Yes.
The Commission ran for 5 years and delivered its 17-volume final report in December 2017.
Correct.
And you've been a Fellow of Monash University since October 2014.
Yes.
And unsurprisingly, in January 2019, you were made an Officer of the Order of Australia.
That's correct.
In April 2020, you were appointed as the Chair of the Victorian Victims of Crime Consultative Committee.
Yes.
In June 2020, you were appointed to the Victorian Law Reform Commission.
Yes.
In July 2020, you conducted the Victorian inquiry into the COVID-19 hotel quarantine program and delivered the final report in December 2020.
Correct.
Mr. Freckleton, you commenced practice as a barrister in 1988 in Victoria, and you become a senior counsel in 2007 in Victoria.
Yes,
And
that's
you're
right.
also a member of the Northern Territory and Tasmanian bars.
Yes.
Now, you've long had a deep interest in coronial systems, and you wrote a book in 2006 with D.L. Ranson titled Death Investigation and the Coroner's Inquest.
Yes.
And you're presently working on a new edition or a second edition of that book.
Yes.
Now, you've made submissions on behalf of the Victorian Bar to the Law Reform Committee of the Victorian Parliament for its review of the Coroners Act 1985, which then led to the Coroners Act Victoria of 2008.
Yes.
Just whilst, operator, might you display exp.002.0013.0016. Since 2000 and might you display the preamble to the 2006 Act, sorry, the 2008 Act, please, operator. Now, Commissioners, one sees that this Coroner's Act has a preamble. Ms. Coate and Mr. Freckleton were involved in, Ms. Coate in particular, in the development of this Act. So it tells one about the coronial system in Victoria playing an important role in Victorian society, independent investigation of deaths and fires for the purpose of finding the causes of those deaths and fires, and very significantly, to contribute to the reduction of the number of preventable deaths, and also the promotion of public health and safety and administration of justice. Now, Commissioners, what this Act did, amongst other things, was create a separate coronial court, of which Ms. Coate was the first Chief Judge, is that?
The role remained still titled State Coroner. But it was the first time that the position was held by a county court judge, and indeed the Act required a judge to hold the position.
Will come later, Commissioners. If might the bottom of that display be shown? Section 1 sets out the purposes of the 2008 Act. And one will see item C there, to contribute to the reduction through the findings of investigation of deaths and the making of recommendations by coroners, a specialist inquisitorial court. So as a watershed moment, as it were, in the coronial system within Victoria, and Ms. Coate and Dr. Freckleton and Mr. Dillon will speak to that in due course. You've been involved in many other things, Dr. Freckleton. I'll merely refer you Commissioners to Mr. Freckleton's curriculum vitae. Now, Mr. Dillon, you're appointed in 1996 as a magistrate of the local court of New South Wales.
Yes.
And in 2008, you were appointed as Deputy State Coroner.
Yes.
And you held a position as Deputy State Coroner between 2008 and 2016.
Yes.
So 8 years working as a coroner.
9, really.
9.
Mm-hmm.
And you are presently a part-time Deputy President of the New South Wales Mental Health Review Tribunal.
Yes.
And you're currently working on a doctorate studying the effectiveness of the New South Wales coronial system in preventing future deaths.
That's right.
And you've been working on that for 3 years or so, or coming up 4 years?
Since late 2018, yeah.
And so you've been deeply studying the operation of the coronial system in New South Wales, reading a lot of literature concerning this whole area.
Yes, a lot of literature.
You are also the co-author of the Australasian Coroner's Manual, published in 2015.
Yes.
And you provided a detailed submission to the Royal Commission.
Yes.
I apologise for interrupting, but I should also indicate, for propriety's sake, that I'm a judge of the Supreme Court of Nauru, and since 2010 have been a member of the Coronial Council of Victoria, but in giving evidence to the Royal Commission, I am not doing so in either of those capacities.
Thank you, Mr. Freckleton. I should have asked you those things. Now, The focus of this Royal Commission is, of course, on deaths by suicide of defence members and veterans. There have been quite a number of those deaths. And really, you fundamentally prevent about what needs to happen to prevent those deaths. Now, Mr. Dillon, you speak in your submission of the significance of one appreciating the common humanity, as it were, of the coronial system.
Well, I speak of people in the coronial system recognising the common humanity of those who've died, their relatives and their communities. Would you like me to elaborate on?
Yes, please.
My experience in New South Wales as a member of the New South Wales local court and as a deputy state coroner was sometimes administrative imperatives and legalistic concerns seem to overtake and predominate in our thinking about how the system should operate. And it seems to me that and this is not just a lofty ideal, if one recognises the common humanity of those who've died, their families and their communities, then that is a guide to how one should act towards them, how one should conduct investigations, and how one should develop a general ethos of the coronial system. So that's why I emphasised that in my submission.
Operator, might you display Mr. Dillon's submission to the Royal Commission into Defence and Veteran Suicide? That is at exp.0002. Operator, might you go to page 33, or it's .0033. And might you display the second paragraph, please, operator? Now, I might ask each of you to speak about the purposes of the coronial system, each from your own experience. Perhaps Mr. Dillon might speak first from his experience as a coroner in New South Wales. This is Mr. Dillon's 4 purposes of coronial systems.
So, coroners always, in every single case, regardless of the circumstances or anything else, are concerned with identifying, in particular, the person who died, the date and place of their deaths, the physiological cause of their deaths, and the circumstances of the deaths. So how the deaths came about. And this summarises, these 4 purposes summarise really, in my view anyway, clusters of ideas. So we're thinking also in any investigation about the possibility of preventing future deaths and injury. We're thinking in terms of how this investigative process could be therapeutic and possibly restorative for those people, which are slightly different ideas. And in many cases, we're thinking about emphasising the respect for life and the protection of life, and that might, and also other elements of human rights, but in particular, the fundamental right to life. So that's how I encapsulate the many purposes that coronial systems have.
Ms. Coate, do you want to speak broadly to that area, the purpose, as it were, of coronial systems?
So I think that Mr. Dillon has done a fine job of setting out the development of coronial practice and its main purposes in terms of where we are at this stage as a civilised society. I'd perhaps just go back a step, if I may, in terms of the more general underpinning of the jurisdiction, in terms of I suppose, the philosophical thinking about why such a system exists, and say that I think as a society we shouldn't and hopefully don't tolerate or accept that the unexpected or unnatural or violent death of any person can happen with no questions being asked of anyone as to the circumstances surrounding that loss of life. And so over the really decades of development of the coronial system, the shaping of what we describe as reportable deaths in the coronial system has developed in that way. In other words, if we as a civilised society, with respect to those reportable deaths, we have to ask what has happened here in an independent and transparent way. So in general, broad philosophical terms, I think it would be fair to say that that's my view of what the general underpinnings are of the system. You put up on the screen, I think just a few moments ago, the statutory purposes as outlined in the Victorian Act of 2008. And that was, those statutory purposes, I think, spell out the way in which the system has been developed and become operational in Victoria, that the emphasis should be on prevention of preventable death, reduction in preventable death, and the promotion of public health and safety. It's the sad reality of the work of the coroner, of course, that the worst has happened at the point at which the coronial process is initiated. And so that such a loss of life doesn't happen in vain, with no questions asked and no lessons learned, in my experience, is not only of some consolation to grief-stricken families, but also to our whole society. Thanks. That's what I wanted to add.
Mr. Freckle, any short thoughts there?
Yes. The coroner is one of several investigators of death in contemporary society. There are specialist investigators into deaths in workplaces, in mines, in maritime and aeronautical contexts, and others. But what distinguishes the coronial investigation when an inquest is convened is that it is open and much more transparent than investigations that are done in other countries, for instance, European ones, where a rigorous investigation may be done, but it's on paper and it doesn't involve the public examination of persons and broader issues. That's one of the distinctive characteristics of the coronial process. The advantages of that are the transparency and accountability to which I have made reference, but also its public nature, the capacity to clarify the public record and alleviate community concerns about deaths. It might be clusters of deaths, or it might be particular forms of deaths. And that's a very significant public interest which is served by the coronial process. The Australian system, which was inherited from the United Kingdom, at first focused upon verdicts, which were often one-word descriptors ultimately of what had happened. It might have been homicide, it might have been suicide, it might have been neglect, or something else. But the last 30 or so years has seen a distinctive evolution of coronial systems in this country and in New Zealand and Canada in particular, with a focus to inquiring more broadly about causes of deaths and circumstances. So not just the medical causes of deaths, but those precipitants to deaths, which can be the subject of constructive inquiry so as to reduce the potential for recurrence of such deaths. And that is the preventative focus that is referred to in the preamble to which you have made reference, and to legislation which, for instance, exists in New Zealand. But it is the culture which has evolved, especially in Australia, New Zealand and Canada, and to a lesser extent in the United Kingdom. And many have said that it's that preventative focus and potential which gives real contemporary relevance to the institution of the coroner. And I'd concur with Mr. Dillon that there are useful focuses to be had in respect of human rights, and in particular the right to life and protection of life, and the collateral benefits, therapeutic and restorative and otherwise, from coronial inquests. But it's really the exploration of the circumstances of death and what can be done to reduce the potential for other deaths that distinguish the modern coronial processes.
Ms. Cope, might you speak of how the Victorian 2008 Act has picked up those ideas and implemented changes and developments? And would you mind speaking to that for a minute, for a few minutes?
Yes.
I know Mr. Dillon refers to the Victorian Act as a major piece of coronial legislation in Australia, but would you explain why it's such a significant piece of legislation?
Yes, I'll just put it into a context in this way. Prior to the redevelopment of the 2008 Act, there was a very significant Parliamentary Law Reform Committee inquiry, which it really conducted an extensive inquiry into the operation of the Coroners Act 1985, as it then was, and produced a very comprehensive report. It took a range of evidence. That parliamentary committee took a range of evidence from a number of people who'd come into contact with the system, as well as through personal tragedy and loss of life, as well as a range of experts. And so the publication of that report, as I said, formed a backdrop for the development of the new Coroners Act, and indeed the reshaping of the jurisdiction. So I think what would be of relevance to the commissioners is to identify some significant differences now in the Victorian system as a result of both that report and then the range of discussions and interactions that were had prior to the enactment of that Act. And the first we've now referred to, which is that the jurisdiction was given a statutory purpose. Up until that point, it would be fair to say, as I think Dr. Freckleton has outlined, that as the jurisdiction developed, there were a range of differences that developed and some differing views about what the purpose of the jurisdiction was, and that led to, I think, some frustrations and inconsistencies in terms of practices that developed not only in Victoria but, of course, across the nation. But these being state-based jurisdictions, Victoria focused on, obviously, what was happening within its own state borders. That led to the decision to put those words into the preamble in the Coroners Act 2008, and also to describe the statutory purpose of the jurisdiction in the way in which that's been done. In other words, Parliament saying this is the work of a coroner's court. It also, so that was a significant difference, to actually have Parliament say that the purpose of the existence of this jurisdiction and this court was to contribute to the reduction in preventable deaths and promotion of public health and safety and the administration of justice. The Act also, for the first time, set up a standalone court. So no longer embedded inside the magistrates' court as it had been up until that point, but now described as a standalone specialist court, a specialist inquisitorial court. And if it's considered helpful to the commissioners, I can expand on that. One of the significances of it being a standalone court, a standalone specialist court, was that the court was thereafter required to produce its own annual report rather than being a postscript in the report embedded into the Magistrates' Court of Victoria. Another very significant difference post-2008 was that, and this came, sorry, I'll start that again. Another significant difference, which was in direct response to the range of frustrations being expressed to that parliamentary committee about coroners' recommendations sitting on shelves, sitting in drawers, with nobody understanding whether or not they'd been implemented, whether or not they'd been responded to, and basically what had happened to them being unknown, not only to the families who'd been so directly impacted, but to the agencies, to the media, to our community more generally. As a result of those concerns, the 2008 Act has now a requirement that after any inquest where a coroner is now required to publish his or her findings and any recommendations or comments that are made in the course of those findings, unless the coroner otherwise orders. And very significantly, the agency or entity that is the repository or recipient of those recommendations, in other words, whoever the recommendations are directed to, must respond in writing to the coroner as to its intention with respect to those recommendations. And when that response is received, unless otherwise ordered, the coroner will publish it. And if one follows what's happening at the moment, at this time in the coronial jurisdiction in Victoria, indeed quarterly reports are now being published by the coroner following those recommendations and the responses to them. In other words, what has happened to the responses every quarter will be published and available to the world at large. Another significant difference is that coroners in Victoria are able to publish, make recommendations and publish them and publish findings without holding an inquest. And also, whilst not part of the 2008 Act, and I'm sure we'll return to this, the development of the Coroner's Prevention Unit, which of course has been an essential part of the ability of the coronial jurisdiction to advance its work in the area of prevention and the promotion of public health and safety. So perhaps I'll stop there.
It may be valuable, Ms. Coate, for you to actually explain to the commissioners the significance of the Crime Prevention Unit operating within, the Coroner's Prevention Unit, my apologies, operating within the Victorian Coroner's Court. What that does and how it does it.
Sure. So the Coroner's Prevention Unit came to life in the wake of the new Act, the 2008 Act. It's, in essence, it's a multidisciplinary collaborative team that sits inside the coronial jurisdiction, works directly to the coroner without, importantly, independently, without any other influence or direction from any other government or non-government department or agency. So that multidisciplinary collaborative team of specialists with expertise in a range of relevant areas actually sits inside the coroner's jurisdiction. So just to give you examples, commissioners, of the sorts of expertise that's now inside the Coroner's Prevention Unit, there's a team with medical expertise, emergency physicians available, for example, to give information, advice and guidance to coroners if that's relevant to any particular aspect of their investigation, mental health expertise, social science expertise, research and data analysis, forensic science expertise available through the Victorian Institute of Forensic Medicine. And also the ability to assist the coroners in the development of recommendations to ensure that those recommendations have the necessary, the greatest prospect of being easily implementable and consistent with the knowledge and understanding of what is required in any particular situation. So the work of the Coroner's Prevention Unit is assisting the coroner to identify potential systemic gaps and failures as the coroner develops his or her work in the investigation. But I should add that part of the work of the Prevention Unit is the monitoring of the daily deaths that are being reported to the coroner, which of course allows the coroner the investigating coroner in any particular case to know whether one of the other coroners in Victoria is also working on a similar case, whether or not it's appropriate to, in the operational language of the court, to cluster together a range of deaths to ensure that deaths that are occurring in similar circumstances have the capacity to have a much greater impact for that investigation in terms of repeat issues that need addressing. And of course, the Coroner's Prevention Unit also produces data back to state and Commonwealth and non-government entities as well to inform their work in improving health and safety. I hope that's helpful.
Thank you, Ms. Coate. In terms of the recommendations and the mandatory response by state and other agencies, it's a period of 3 months, is it, that they must respond within 3 months?
That's correct. That's the statutory requirement, that they must respond within 3 months.
And what happens so far as that response is concerned? Is there then analysis or review of that response apart from the public display of the response?
Certainly the public display of the response, and as you can imagine, all agencies are very mindful of the fact that their response is going to be publicly displayed, which of course can have a very powerful impact on the way in which that agency considers what it should or shouldn't do, or should or shouldn't say in response back to the coroner. But it also means that tragically, if another death in similar circumstances occurred, just to give you an example, in circumstances where the agency if the agency's response back to the coroner is, no, we don't consider it's an appropriate use of resources to implement that recommendation, that's publicly sitting there in the event that there's another death in similar circumstances. It gives much more power, I think, to then future coronial investigations to say, well, this was your response, for example, on the last occasion, a death in similar circumstances has occurred. Perhaps you should reconsider your position.
Is there capacity to examine the response and to interrogate the agency concerning the response within the Coroners Act 2008?
If you mean to court, you mean in the sense of recalling that party?
Yes, or alternatively, asking them if there's a very short and brief response to take it further. Is there capacity to explore the basis for the perhaps non-acceptance of a recommendation?
Not a formal statutory basis, no. There would be nothing to inhibit a coroner from, upon receiving such a response, to make a further inquiry if there's something not clear about the way in which the response has been put. No. If I've understood your question correctly, yeah. No, and the reason behind that is that, of course, once the investigation has been completed and the statutory requirement of the response has been made, then that really means that the coroner, in legal language, is functus officio. In other words, has finished that task. But as I said, the power of what's sitting there is that it's made public, and advocacy groups have been quite active in using those recommendations to continue to pursue issues with the agencies, as well as individual families on occasions to great effect.
Mr. Frecklin, would you have a very short comment on the significance of the Coroners Prevention Unit within the Victorian coronial system?
Yes, it's certainly a unit which enhances the capacity of coroners to identify clusters of deaths which need further investigation, and it assists in the quality and formulation of the recommendations that we have been discussing. So it plays quite an innovative and significant ongoing role in that aspect of the coronial function. There are one or two other aspects to the new legislation to which reference could be made, but let me know if you'd like to hear
about
those.
Those labels at the moment. So far, we have the Coroners Prevention Unit and the power to make recommendations and require mandatory responses. What might be the labels of the two additional items that you'd like to mention?
The first one is the required publication of findings, recommendations, and comments, which makes the work of coroners in respect of full inquests and also paper inquests much more publicly accessible and useful. The next is the set of objectives which are set out in the new legislation in section 6 and following, which give better and clearer guidance as to how the jurisdiction ought to be exercised by coroners and all others working within it. The next is the creation of the Coronial Council of Victoria, which advises the Attorney General about the operation of the coronial system and legislative and procedural changes which might be contemplated in relation to it. And the next is the ongoing interaction of the court with the National Coronial Information System, the NCIS, which is a repository of information about some 400,000 deaths that have been investigated. All of that leading to greater capacity to access and utilise data from the coronial system.
Thank you, Mr. Freckleton. Mr. Dillon, might you have any short comment about any of these items?
Well, I agree absolutely with what Ms. Cozen and Dr. Freckleton have said. One thing I could add, I think, is that, in my view anyway, the Victorian system is more or less the gold standard. It's probably the best coronial system in the world. And the only other coronial system, it seems to me, that comes anywhere close is that in Ontario, although I don't think it's quite as good. Certainly New South Wales is not anywhere near as good as this system because it is incomplete. It does not have some of these other modern features such as a preamble, objectives. It doesn't have a research capacity. It's more or less a cottage industry spread out all over New South Wales. So when one looks at Victoria, I think we're looking at more, and I'm sure Victoria can be improved, but we're looking at the best in the country and probably the best in the world.
Now, you also have regard for the New Zealand coronial system, I understand.
For the New Zealand legislation, I do, yes, certainly.
Sorry, the New Zealand legislation. Are there particular aspects of New Zealand legislation that you find valuable?
Well, I think they're similar things to those that the Victorian legislation presents, namely a focus on prevention of future deaths and injuries, and also an orientation towards caring for the needs of families. So, and I think we haven't talked much about that, but I think they're interrelated. And this is why I mentioned the idea of an ethos or a normative theory of respect for, recognition of common humanity. If we get that recognition of who the people we're trying to help here, then we will investigate deaths properly and try and prevent future deaths. We will pay proper respect for lives. We will try and operate in a therapeutic or restorative way. So I think Victoria and New Zealand do these things and both have that kind of orientation.
Coming to communication with families, we've heard some lived experience witnesses here who have little or no communication with the coronial system. Now, how is that falling down? If that's happening, how's it falling down?
Well, I think it probably is happening. I can only speak in regard to New South Wales and probably a little bit in relation to Ontario. We know that families suffer if they are not kept in the loop, if they don't get the information. Families are suffering from uncertainty. They're suffering grief and uncertainty and a sense of impending, almost existential threat because they don't know what has happened or why something shocking has happened to their loved ones. They need to be kept in the loop. They need to be told what's going on. Secondly, they need to, if an investigation goes for quite a long time, as they can do, they need to be regularly updated. They shouldn't have to go to the coroner's courts or a coroner or an officer of the court to find out what's going on. There should be some sort of regular communication with them. And thirdly, I would say, and I'm just talking about New South Wales here, some of the correspondence that people get is frankly officious and brutally legalistic. It is not kind, it's not caring, it's not therapeutic. It is focused on administrative imperatives and not the needs of families. So I think there are those kinds of problems in the communication. In New South Wales, if a death occurs in the metropolitan area, then there are specialist family liaison officers and grief counsellors who will directly deal with families. And that can be very, very helpful, I think. But if a death occurs in the country and the death is reported to a country magistrate who is also a part-time coroner, then that form of close connection doesn't exist really. And so we have a hybrid system, a two-tier system in New South Wales. There's specialist coroners dealing with some deaths and country magistrates who are overworked on their criminal work and their civil work and so forth, having to manage also coronial responsibilities. And it can fall down there.
Just some numbers very broadly. Some 6,500 or so reportable deaths each year to the state coroners.
To the New South Wales
to the New South Wales state coroner. Some 55% or so come to the coronial system in Sydney.
Yes.
And 45% go to country magistrates.
Yes.
Who have no deep and prolonged experience in coronial matters.
Yes, that's right.
And you have 5 coroners, I understand, operating in New South Wales.
I think it's now specialist coroners. I think it's now just gone up to 6 recently.
And Ms. Coate, I understand that in Victoria there are 14 coroners.
Yes, that's right. The numbers have just gone from 12 to 14. And unlike the system in New South Wales, Victoria's system is a centralised one where those full-time specialist coroners attached to the court are all based at the court's facility in Melbourne and doing that work. Also, I should just add, and I agree with everything that Mr. Dillon said in terms of describing the needs of families. And if one looks back at that Parliamentary Law Reform Committee report I referred to, it is replete with the agony of families and their unhappy interactions with the coronial system, and indeed was I think part of the impetus for that Parliamentary Law Reform inquiry in the first place. The Victorian Court also has family liaison officers attached to it whose purpose is to support families right from the very outset, as in their first communications with the court that may well require them to be supported through some of the very difficult early stages of the investigation, and then to communicate with them throughout the process. During my time in Victoria, one of the difficulties we faced with those family liaison officers was the ongoing funding of those positions. There were serious difficulties with an understanding of the need for specialist coroner's court family liaison officers there was a view that was taken at that time towards the end of my 5-year period that those family liaison officers were replaceable with community health centre support services, and despite being very unhappy about that decision, I think there was an interruption to the specialist family liaison officers for some time at the court, which I thought was an extremely unhappy circumstance.
Mr. Dillon, I understand that in New South Wales there are about ordinarily year by year 120 or so inquests per year.
Roughly that, yes.
Yes. Now, I think both Mr. Freckleton and Ms. Coate have spoken of the Victorian, under the Victorian Act, there is provision for detailed reports of investigations into deaths, and particularly systemic analysis of those deaths that can exist, or it does exist, independently of the inquest. Have I got that right?
That's a question to me.
It's really a question to Ms. Coate and also Mr. Freckleton.
You have got that right in that there is the capacity for coroners in the 2008 Act to make recommendations without inquest and publish those findings.
And they can be quite detailed findings.
They can be very detailed findings indeed. And if one has a look on the website of the Victorian Coroner's Court, you'll see a range of examples of exactly that.
And Mr. Dillon, that doesn't happen in New South Wales?
No. In fact, there was a suggestion a few years ago, about 3 years ago, that the Act be amended to enable the Victorian practice to be implemented. That was a recommendation of then State Coroner Michael Barnes, but it was rejected on the basis that it would be there were insufficient resources, so the situation now is in New South Wales that it's only at an inquest that coroners have statutory power to describe the circumstances of the death and to make recommendations. If they don't hold an inquest, they have no power to do that under the Act.
Now, might we turn to death by suicide and the investigation of death by suicide, and also, in particular, deaths by suicide of members of the Defence Force and veterans. Might we perhaps start with the nature of the reports or the significance of the initial police report to the coroner in the information that is then available to the coroners to commence their work? Ms. Coate, would you mind speaking to that first, and perhaps about what you regard as an appropriate body of information to be provided to the coroners by way of the police report?
So, just to make it clear, I'm sure, obviously, Commissioner Caldos will be well aware that it's the members of the state and territory police forces generally that are conducting those investigations for coroners and making reports to coroners. The various forms of those police bodies might have different names and numbers and descriptions, but the effect of them is the same. In other words, they are making the initial report to the coroner. in whatever particular form the domestic police force has described. That the contents of that initial report to the coroner, it would be fair to say, is somewhat variable. It'll depend on the particular knowledge of the investigating member of the police force, the time available to him or her to prepare that initial report to the coroner, their understanding of what's required of the coroner. And so in that sense, the contents of those reports can be variable. So sometimes there'll be a significant amount of information initially given in that first police report to the coroner, and sometimes the coroner will need to ask a number of questions back to the police member to understand exactly what is being reported and what the full detail is. There have been a number of attempts to create a standardised police form across the nation. Before I came into the role at the end of 2007, I'm aware that in the years before that, there were endeavours to create a standardised police form that would pick up a range of information and be flexible enough to take direction from the national body of coroners about what developing further information might be of value. As I understand it, the jurisdiction in Queensland has now adopted the recommended standardised police report to coroner, and I'm not sure what the range of other jurisdictions involved have done, but as my recent inquiries of the Victorian jurisdiction are, that there is still no agreement, no standardised police form operating in Victoria, picking up, by that I mean a minimal set of data and information to be provided to the coroner. For the purposes of this commission, of course, that would be knowledge or information about the particular background of the person who has lost their life and thus become a reportable death to the coroner, whether or not that person is a current serving member of the Defence Force or indeed is a veteran. Of course, one of the advantages, I should add, of the Coroner's Prevention Unit in the Victorian system is that the Prevention Unit, as I explained before, the staff in there are daily monitoring those reports and are able to alert the coroner to the fact that no, that information hasn't been provided in the initial report, and does the coroner want those questions to be asked back to the investigating member to provide that information. There's absolutely no reason why that couldn't and indeed shouldn't be happening.
Commissioners, by way, just for the record, the Queensland Form 1, the copy I have in front of me is 35 pages long. I understand that from that form will emerge 107 variables, and it, for example, that system then is able to be utilised as to found a interim suicide register which is prepared within days of the death of a person by suicide, which then allows analysis immediately, such that there are now papers published on did COVID make a difference to the incidence of suicide. So that will emerge in later hearings, Commissioners. So now, Mr. Dillon, might you comment on the New South Wales position as you understand it so far as the
Well, I, I have to say I'm not a police officer, so but I do have in front of me a blank copy of the P79A form, which is entitled "Report of Death to the Coroner," and this is a form which is very familiar to me. It's 5 pages long. My understanding had been that, in fact, the New South Wales police form was was a uniform form, standardised across the country. But I've learned from Ms. Coate that that is not the case. And hearing that there's a 35-page Queensland form persuades me that there is no standard form, or at least there are maybe 2 standard forms or something.
Some differences.
In any event, in relation to the New South Wales police report of death, there aren't any demographic details concerning a person's Defence Force service, past or present. So that's one thing. There is opportunity for the responding officer or the responding police to describe their initial view of the circumstances of death, whether the death appeared to be suspicious or not, and they can provide some sort of narrative of the circumstances under which they understood the death took place. But as Ms. Coate has described, this is very much a first go at putting together the picture that then has to be explored. What happened in New South Wales was that first picture would be explored by way of further police investigation and medical investigation, and depending on what emerged from those further investigations, there may be more or less complex investigations conducted from there.
Now, Mr. Frecklin, do you have any short comments on this general topic of the significance of the initial information that's provided from the police?
The initial information provision is fundamental in alerting a coroner to issues which need to be looked into further. So having a comprehensive, guided provision of information by a well-drafted pro forma would be extremely advantageous. The length of it is something that needs to be looked at so that it's practical and so that it provides what is necessary. But there is an additional consideration. Coroners are investigators, and a competent and industrious coroner, when she or he receives information that is inadequate, should be asking for additional information, for ample powers to enable that. And coroners routinely do just that. They ask for more and better so that they are sufficiently apprised of what they need to know in order to make findings and advance recommendations, or to make the threshold decision as to whether to convene an open inquest.
That would depend, of course, on their load and load of cases, apart from coronial cases, such as a magistrate in a town in country New South Wales.
Yes, that's right.
Could I comment on that additionally? One of the problems with having country magistrates dealing with these cases is that if there are systemic issues, they may not recognise them. In New South Wales, people appointed to the local court are sent to do country service very early on in their careers as magistrates. And so they may be an inexperienced magistrate as well as being an inexperienced coroner, who then does not develop sufficient volume of experience as a coroner to develop a sense of the complexity or sensitivity or systemic issues that evolve. So if you compare, just to take an analogy, a person working in an emergency department in a big city hospital dealing with lots and lots of cases with a locum doctor working in a small country hospital, that's the difference between a full-time specialist coroner and a country magistrate looking at these cases.
Now, Ms. Coates has referred to the value within or the advantage within the Victorian system of it facilitating systemic analysis of clusters of cases. Now, how does that work in New South Wales? Is that possible?
Well, there's no systemic way of doing this. In fact, identifying clusters or patterns and trends of deaths is serendipitous in New South Wales. It is sometimes as random as someone sitting in their chambers and two similar case files landing on their desk. But generally speaking, it is something that develops over time. I may see over, say, a year or 2 years or 9 years, a number of similar kinds of cases. But there is no one sitting in a registry or a research unit analysing these cases as they come in. And that's one of the beauties of the Coronial Prevention Unit, as Ms. Coates and Dr. Freckleton were saying. There is constant real-time analysis of cases, of incoming cases being done, which enables coroners to say, oh, we need to have a look at this, we need to have an inquest, or we need to gather more information, or we need to get further information from other sources to try and work out how we can go about our task of preventing these kinds of deaths. It can be done much more efficiently in Victoria than in New South Wales, and probably than in most other Australian jurisdictions.
Might we turn to the topic of suicide, and particularly amongst veterans and Defence Force members, and the idea of suicide itself as a notion. Mr. Freckleton, would you speak to that for a minute?
Yes, suicide is a very emotive shorthand descriptor. Often in discussions of these matters in the coronial context, reference is made to a 1970 decision. And if I might, I'll just quote what Justice James said in that. It's the Queen and Cardiff City Coroner ex parte Thomas. Justice James said, "Suicide is voluntarily doing an act for the purpose of destroying one's own life, while one is conscious of what one is doing, and in order to arrive at a verdict of suicide, there must be evidence that the deceased intended the consequences of the act. If it be the case that questions of accident and questions of suicide arise, the mere fact that accident was not established does not mean to say that suicide is established." Now, the point that judgment in the English High Court makes is that inherent to the notion of suicide is that a person who is competent to do so intends to do an act that brings about death, understanding the nature of the act and that it is likely to bring about death. What follows from that is that one might have real reservations about determining that a person who is psychotically ill really understood the nature and consequences of what they were doing, or a person who was very young, as in the case to which you've made reference of Cassidy, upon which Judge Coates, as she then was, sat. The key issue in respect of suicide is that it is emotive, stigmatizing, and complex. people's capacity to understand what they are doing and what the consequences are likely to be can be clear in some cases where there's a suicide note, but very ambiguous in others, where the person's capacity may wax and wane, where the person may change their mind at the last minute, perhaps too late. That is why coroners have different approaches in terms of their preparedness to make findings about suicide. Suicide is one of those English verdicts which Australia inherited. Largely, Australia has moved away from simplistic single-word descriptors of cause or circumstances of death, and we tend to focus on narrative descriptions which are much fuller of content and substance. But to the extent that suicide remains as a finding in Australia, it is often problematic because the facts surrounding a particular death do not always enable a straightforward determination of whether the person actually intended to kill themselves. The archetypal example is a single vehicle accident where a person crashes into a tree. It might be that the person deliberately drove into the tree. It might be that they were driving really badly, or it might be that there was some kind of a distraction or an accident that resulted in a fatality. That's a straightforward one, but also where drugs of one kind or another are utilised, exactly what was intended by the person who ends up being deceased is not so easy to determine. It might be that there was a cry for help. It might be that the person accidentally took too much of a highly noxious substance, or it might be that they absolutely deliberately intended to terminate their life. But even in the latter case, if they were psychotically unwell at the time, one might be hesitant to attribute to them the capacity to make a reasoned decision in that regard. So what is necessary is to go beyond the simplistic utilization of a single word descriptor, and for a coronial officer, a coroner, to consider broadly the circumstances of a death which may have been occasioned by a person's own actions, and to reflect upon the intentions and the capacity of the person at the relevant time to formulate in their minds an intention irretrievably to terminate their life.
Ms. Coate, do you have any observations on that notion? I know you've written on it in the Cassidy case.
Yes, and for obvious reasons, I don't intend to comment on that. Mr. Connor, can I just make the observation? And obviously, it's very much in the forefront of the Commissioner's minds, given the nation of this Royal Commission. But these are very difficult conversations to have publicly. The reason, and I agree with what Dr. Freckleton's had to say, so with respect, so eloquently, and thank you. One of the issues that pervades the, I guess, the public health community with respect to this topic of suicide is a concern about consistency of reporting of for coroners in terms of their what findings they make, and a real concern about a level of underreporting that diminishes the actual number of intentional deaths, intentional taking of life, or suicide. And it's readily understandable why the public health community are going to be concerned about that, and no doubt it's a concern indeed of this very Royal Commission. One of the developments in Victoria acknowledging that difficulty in terms of trying to get a consistency of language is that one of the responses has been that in collaboration with the Judicial College in Victoria, the court has settled upon a template finding which endeavours to assist the coroners to use consistent language and, where possible, to address that issue of intent. My personal view is that that is a good development, but it's not to diminish at all the issues that Dr. Freckleton has very properly identified about the difficulties that coroners face every day when there's a presentation of ambiguous facts, as it were, surrounding the circumstances in which a person has potentially acted to take their own life.
This, of course, has significance in terms of what might be called data, but what is its significance, Dr. Freckleton?
It is in the community's interest that we have as accurate data as possible as to the phenomenology of suicide in the broad, and for the purposes of this hearing, in relation to the suicides committed by former or current members of the armed services. This issue arises in many contexts, and another one is in relation to persons who have been concussed, where we need more data in that regard. There is a tension between the obligation of coroners to make sound, factually based findings in an individual case and the broader public health perspective, which seeks out as extensive and accurate data as possible in order for public health decision making to be as sound as possible. The Coronial Council of Victoria was asked to explore some of these matters and reported to the Attorney General in 2014. It noted that suicide was the leading non-natural cause of death in Australia, and identified that inconsistencies in coronial practices hinder the accurate collection of suicide data. The Council ultimately recommended that there be a legislative requirement that coroners make a clear finding about the intention of people whose actions cause their own death, where evidence so permitted. And that was an attempt to enhance the capacity of persons looking at coroners' decisions to determine whether, in the sense that I described previously, a death brought about by a person was properly to be described as a suicide, because there are many coroners who decline out of sensitivity or hesitancy to deploy the descriptor suicide, and that, of course, adversely affects the capacity to identify, for instance, how common the phenomenon of suicides is amongst servicemen and ex-servicemen. But what we are looking at here is a tension that I've described already, and I'd like to emphasize that although having narrative findings which do not utilize the word suicide is unfortunate in terms of compilation of statistics from a public health perspective, that does not detract from the utility of sophisticated, carefully reasoned decisions by coroners which explore the circumstances of death, utilising a psychological autopsy to the extent that that is possible, to determine whether a person intended to bring about their death or whether there were other factors which brought about their behaviour in the particular circumstances. Because those kinds of findings inform community knowledge in the broad and enable in potential strategies to be developed which are more than just based on the incidence of suicide, but are informed by knowledge about the circumstances of such deaths.
Ms. Coate, I noticed that you were agreeing with various aspects there. Are you broadly in agreement with what Dr. Freckleton is saying?
Yes, I am. Yes, I am. And I thank him for that articulation of the issues and agree.
Mr. Dillon?
Yes, I completely agree. In fact, I have to confess, I was, as an inexperienced coroner, I was one of these people who underreported deaths as self-inflicted or suicide deaths because of those concerns that Dr. Freckleton and Ms. Coate have talked about.
Now, might we turn to another topic, and operator, might you display exp.0002.00013.0017? Ms. Coate, I'm turning to the Victorian Systematic Review of Family Violence Deaths Unit. Commissioners, Dr. Coate in her paper in section 3 of her paper from 2009 describes this system in detail, and on page 7 of that paper there's reference to the 3 main alternatives in Victoria and the ultimate choice being made to have a model that gathered together, became a collective enterprise, as it were. Would you mind explaining that, Ms. Coate?
Certainly. Perhaps just before I do, if I can put it into the context, excuse me, that I think is relevant to the commissioners and their deliberations and considerations for this particular aspect of their work. There is no, I'm sure the commissioners are aware, but just for the sake of completeness, there is no federal system, coronial system. So each of the coroner systems are state or territory-based systems. And whilst there has, and there has during my time and remains a really fine level of cooperation between the state and territory coroners, I think you would find that each of the coroners have reported difficulties and frustrations from time to time when having to deal with the Commonwealth and obtain information and cooperation from the Commonwealth. So I just put this family violence systemic review model into that context. That it is now a model of investigation into family violence related deaths that exists in each coronial jurisdiction around Australia. Its establishment in Victoria, as you can see from the detail in that paper, came as a result, of course, of a growing level of horror about the numbers of deaths, in particular of women and children in family violence-related circumstances, and an acknowledgement that something more systemic and analytical and ongoing needed to be set up to examine exactly, to examine whether or not patterns and trends in these deaths could be identified to assist in the reduction of those deaths. So as you can see on that page 7 that you've been referred to, Commissioners, consideration was given to 3 main alternatives. Ultimately, the decision was made for the reasons that are set out on that page to place those systemic reviews into the coroner's jurisdiction. And I think those reasons set out on that page speak for themselves. These deaths are all reportable deaths. The coroners have a range of existing powers already. They are independent of any government agency. And of course, post-2008, when this model was developed, have those range of recommendation powers that we've discussed, as well as the mandatory requirement for the agencies who are the recipients of those recommendations to have to respond. So the model, the review team are funded by the each state and territory government, and they, in Victoria, the model started, I must say, without any legislative basis, but with funding made available to the court to engage staff with a range of expertise and specialisation to assist in the development of that model. Importantly, and this is set out in the paper, importantly, this model has a reference group that is an available body to the investigating coroner in his or her death review process to go and seek further information from. So that reference group is a group of people that range from members of Victoria Police Force, various members of public health systems, all the way through to a range of advocacy groups that are available to give general information and advice to the coroner conducting that family violence death review process. It again gives the capacity with the resources provided to the coroner through that extra staff to conduct a daily monitoring of all of the deaths reported to the coroner, identify potential family violence related deaths, see trends, patterns and systemic issues that are coming through in those deaths being investigated by the coroner, and assisting the coroner to then not only conduct those investigations but make obviously meaningful both comments and recommendations in the wake of those investigations.
Now, in relation to members of the Defence Forces or former members of the Defence Forces who have may have died by suicide. Now, what might be models for a better, improved, systematic review and analysis in an ongoing way to deaths amongst defence members and veterans? And might there be some ideas drawn from the family violence death reviews system? Appreciate your comments on that or observations on that. Might we start, Ms. Coate, initially?
Well, I wonder whether or not perhaps Dr. Freckleton might make some general observations about a possible federal system of coronial investigation and its constitutional possibilities.
You're welcome to proceed, Mr. Freckleton.
Thank you. This difficulty in relation to the investigation of a range of deaths has troubled coroners, to my understanding, for a considerable period of time. The issue arises in respect of deaths, including those of personnel in the armed services and the Australian Federal Police when they are stationed overseas. Also Australian residents when they are temporarily overseas, and also persons in immigration detention, as well as persons in a variety of Australian territories. Each of those categories of deaths provides real fact-finding challenges for coroners needing to utilise the assistance of personnel overseas and the assistance of the Department of Foreign Affairs and Trade and the Australian Federal Police. And that combination of factors has led to the mooting of the potential for a federal coroner with jurisdiction to look into a range of those issues. To my knowledge, such an option has not thus far gained traction, although it manifestly has some utility. Under Section 71 of the Constitution, there is the potential for the Commonwealth Parliament to create federal courts. There would need to be the requisite connection to heads of Commonwealth power. And this is probably not the time to discuss those in any detail. There are a number of potentially relevant heads, relevant in the context of what is the business of this commission. One is Section 51(6), which relates to a naval and military defence of the Commonwealth. That might be a sufficient nexus, although reasonable arguments could be had about that. And there are various other heads of power which might exist under Section 51 of the Constitution. The advantage in potential of such a federal system would be that it would create a repository of expertise in this kind of investigation and a skill set in terms of utilising federal Commonwealth agencies, including the Australian Federal Police and the relevant Commonwealth departments. There is also a sufficient incidence, tragically, of deaths amongst serving and former diplomatic personnel, members of the armed services and of the Australian Federal Police, to mean that such an entity as a federal coroner would have a significant amount of work to do. So it's in those circumstances that there have been discussions over the last 20 years about whether such an option, if it is constitutionally possible, might have utility. But I think what's been raised by yourself and by Ms. Coate is the potential to adapt what exists already in Victoria and by way of collegiate arrangements already amongst the states as a mechanism for investigating another category of deaths. The Section 102U option under the Coroner's Act in Victoria is focused only, and I don't mean that disrespectfully or to minimise it, but on reviews of family violence deaths. There are other categories of deaths, in particular amongst the persons who are of particular interest to this Royal Commission, that could usefully be the subject of formal recognition and ongoing review by a unit replicated in each of the states and territories. And the advantage of that would be that there is a mechanism to draw upon and processes and systems to deploy. But otherwise, I'd defer to what Ms. Coate has to say on the topic.
Just could I clarify a couple of matters? It wouldn't be a Chapter 3 court, of course, would it? It'd stand apart from Chapter 3.
It would be a federal court in that at the moment what happens in respect of these inquests is that an individual state or territory undertakes the investigation. And sometimes that's done effectively and other times not so effectively. But there is the potential for the creation of other federal courts under Chapter 3. But that's something that's been done with the Federal Court, of course, and its recent manifestations. And the question would be whether a federal coroner's court might be created. I'm not proposing it. I'm simply identifying that this is an issue that has been discussed.
Two issues. One, is there a matter for the purpose of Chapter 3? And second is, you may well be able to do it outside Chapter 3 as the military justice system is working.
Yes, that those are the matter may be able to be found, although in my preliminary view, it is somewhat strained under Section 51. But yes, the option for doing it under that alternative system is another option.
Ms. Coate, would you mind speaking a little about the model of the family violence death reviews system and the values of that, and how it might be adapted or applied in relation to members of the Defence Forces and former members' deaths by suicide?
Yes, and can I just start my answer or response to that by saying that whilst the intricacies of the law and our federated system here in Australia might ultimately allow for a federal coronial system to be developed, that thought has been around for at least the last 15 years, come to the surface from time to time, and so far, to the best of my knowledge, nothing has happened in that regard, and the Commonwealth at any stage has not shown any interest in responding to various representations that have been made to consider that possibility. So I think the very basis of this Royal Commission, the tragic loss of multiple lives to suicide, requires a far more urgent and practical response than the setting up of a new court. And so I come back to looking at the reasons why ultimately the then serving Attorney General in Victoria back in 2009 took the view that the best way of giving proper, systematic and comprehensive analysis to the tragic number of family violence-related deaths was to properly resource the coronial system that's already a standing system with the range of all necessary powers that would be needed to set up the capacity to have a systematic and systemic ongoing capacity to identify defence and veteran-related suicides and constantly keep under examination what those repeat patterns and trends are, for the purpose of course, endeavouring constantly in a standing body like the coronial jurisdictions to address those repeat patterns, address the issues that families are reporting are ongoing and systemic issues with various both state and Commonwealth agencies, and use the powers the coronial system has to make ongoing recommendations about what should happen. And hence, I think the concentration in the earlier part of our evidence about the Victorian system, which provides for the mandatory publication of the work of the coroner, being relevant to setting up a model that would be of ongoing value to this the substance of this Royal Commission.
Ms. Coate, in relation to the recommendations that are made in connection with the family violence death reviews to an agency, say that that was a Commonwealth agency. Has that occurred? And has there been any pushback from the Commonwealth agency?
So that's a very relevant question to ask and a difficult one to answer, in this sense that coroners can make recommendations to any entity or agency where the tension lay is whether or not a Commonwealth agency is obliged under a state act mandated to give a response. So that's, in this context, that's an issue that would have to be addressed. The Commonwealth bodies would have to, the relevant Commonwealth bodies for this Royal Commission would have to give a commitment to cooperate with state coroners. So, in other words, if such a model was set up inside the state and territory coronial jurisdictions, it would only be effective if the relevant Commonwealth bodies confirmed, possibly to this Royal Commission, that they would cooperate with such a model ultimately, if that was a decision made by the commissioners that that was an appropriate thing to do. So, in other words, there's some work to be done. It's not as straightforward as the family violence model, because each state and territory coronial jurisdiction is making recommendations back to state agencies in their own jurisdiction, as well as collaborating with each other about the issues that are coming up in the, there is a national body that collaborates across the jurisdictions with respect to family violence death reviews and the patterns and trends and themes that are coming up out of those reviews.
Might I turn to the topic of mandatory inquests? And under legislation around Australia, the various Coroners Acts, some particular categories of deaths are required to have an inquest. Could I get your comments on, observations on whether mandatory inquests into defence members, deaths of defence members, would be a valuable thought, and also veterans, or not. Ms. Coate, would you mind going first?
Yes. I can completely understand why that, on the face of it, might look like a good option to add into the list of reportable deaths requiring mandatory inquests. However, I caution against doing that. And I caution against doing that as a result of my experience over the years of my work inside the coronial jurisdiction. And I say that because it was my experience that families would sometimes be terribly distressed at the prospect that their personal and intimate details of their loved one's life and death were going to be examined publicly, and that it was indeed going to be counter-therapeutic to them for that to happen. And so I ultimately would come to the view on that question that it is a discretion better left in the hands of the coroner to be able to listen to the family in that regard, consider all the whole range of factors as to why a coroner would decide to proceed with an inquest or come to a conclusion in a particular matter, writing a finding but without inquest.
Dr. Freckleton, you have a similar view?
Yes, I do. I think the issue is finely balanced, and in all jurisdictions there are multiple categories of deaths that are reportable, and there's a connection between the reportability of death and the holding of an inquest. But what the process as currently it exists in all jurisdictions in Australia permits is the kind of flexibility to which Ms. Coate has just referred. And in determining whether or not to hold a public inquest, a variety of considerations are taken into account by a coroner. Those incorporate the significance of a death for the Australian community and issues arising in relation to prevention and the dealing with the correction of the public record, the clarification publicly of what has taken place, but incorporated to the wishes of colleagues, family members, and friends. And that can be a difficult juxtaposition of perspectives for a coroner, but mandating an open inquest in every such case undoubtedly would enhance the availability of data, but it would cause a substantial amount of distress for a significant number of families. And my view is that it is better left to be discretionary decision-making of coroners.
Mr. Dillon, are you of the same view?
Yes, I am. And for the reasons that Ms. Coate and Dr. Freckleton have said, I think one of the things needed to be done in New South Wales, though, and possibly not so much Victoria, because I think they do this well, but that is that coroners have a very wide discretion, and there's not a great deal of guidance in New South Wales local court materials as to how coronial discretion should be exercised. And I think that's a real problem that needs to be addressed. And it may be that special emphasis needs to be placed on consulting with families in relation to defence and veterans' deaths in this state. I really have no idea, apart from Victoria, what might be the situation elsewhere.
There are very few inquests in New South Wales into persons dying by suicide.
Yeah.
And then again, there's very few, even fewer, deaths of defence members or veterans. Is that the position?
I believe so. I don't have the statistics available to me.
Dr. Frecklin, is that the kind of position across Australia, that there's very few coronial inquests into defence persons dying by suicide?
My understanding, yes, and the broader question is a correct one in my respectful opinion to ask as well. How many deaths by apparent suicide are the subject of inquest? And the answer is that it is comparatively few, because coroners find that the balance between the utility of undertaking such an open investigation and the distress caused by it, much of the time does not justify such an exercise being undertaken.
And I may add, it would be very rare to do this without a request from a family to do so.
Yes, that is right. In the system that exists in Victoria, for instance, though, that does not mean that an investigation is not undertaken and is not written up, because that can be done in Victoria without there being an open inquest. And it routinely is, and there have been some very important and substantial paper inquests, if you like, that have been undertaken with significant recommendations advanced and lengthy findings that have been advantageous for all concerned without the formal convening of an open inquest.
And you've also got the coronial prevention unit in operation in Victoria, with its with the benefits and advantages that derive from that could enable a systemic and proper analysis of deaths by suicide generally, and also deaths by suicide amongst Defence and Veterans Affairs. Sorry, Defence and Veterans.
That's right. What we're talking about in different ways and in different language is the inclusion of a sophisticated epidemiological perspective into the analysis of deaths by coroners' courts, specifically in this context in respect of veterans and serving members. And the crucial thing is that there be that inclusion of the epidemiological perspective, so that coroners are seized of the broader picture, so that they can evaluate trends and patterns, not just about the incidence of deaths, but about deaths on a particular ship or in a particular location. So those matters come to their attention and enable the investigation of such matters in the public interest.
Sorry, Mr. Connor. Can I make this point? If the three big states on the East Coast operated the way Victoria was, that would cover something like 75% of the population, and it would cover most of the large defence centres and bases and so forth. So, and Queensland and New South Wales really are the two centres, or the two jurisdictions that need to be reformed to adopt this epidemiological approach. But if that was done, you would largely solve the problem of these investigations being so random, I think.
Might you each stay online, as it were, past 4 p.m? I've taken a little bit longer than I expected, and Commissioners, if you have any questions.
Yeah, there will be questions from the Commissioners, if we could just factor that in, and we're grateful for your time.
Sure.
I've finished my questioning.
Thank you, Mr. Connor. Commissioner Brown?
Thank you very much. I have a few questions. Firstly, I'm just wanting to get a sense of some of the relativity. So we had the numbers around the number of reportable deaths in New South Wales being around 6,500, I think we heard, and about 120 inquests. I'm just wondering whether there are similar figures from Victoria in terms of the number of reportable deaths and the number of inquests and then the number of inquiries or investigations.
So, Commissioner, the taking the figures from the annual reports coming out of the court, the Victorian figures are about 7,000 reportable deaths per year. The number of inquests so the last, the annual report for last year had the number of inquests at, I think 60.
58, was it?
Sorry, 58, yes. And that percentage of reportable deaths and number of inquests has, on a quick glance, remained reasonably steady over the last few years inside the court. So it's a per pro rata lower figure than the number of inquests conducted in New South Wales, the two jurisdictions that we've been comparing throughout our evidence today. One of the explanations for that may be that, as you've heard us talk about, that coroners have the capacity to give detailed findings without conducting inquests and indeed make recommendations without conducting inquests.
And sorry, so how many of those detailed findings without an inquest would happen each year in Victoria? Just as a rough figure.
It's a good question and one that I don't have the answer to. What I can tell you is that the last annual report noted that there were 204 recommendations made by coroners. So that includes across both findings and recommendations with inquest and without inquest. But what the breakdown of those circumstance findings is, detailed circumstance findings, is compared to inquests. I'm not sure that that's a figure that's collected. Dr. Freckleton may be able to correct me on that.
No, I don't believe it is collected. There are substantial numbers of inquest findings where matters haven't gone to an open inquest, though, and they can range to findings of 20 or 30 pages.
Correct.
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 Can I say this too, that the figure we've been referring to was last year's figure of 58 cases closed with an inquest. The numbers are a bit variable. In 2015-16, there were 131. There were 82 in the year after that. So the numbers move around a bit. And of course, the last years of COVID have affected the numbers of cases resolved in that way.
Thank you. I guess the reason for just wanting to understand those relativities kind of leads to my next point, which is around the resourcing required. And we did hear, about the importance of having adequately resourced units. And from what Mr. Dillon has described, the resources available in New South Wales clearly sit well below what's available in Victoria. But I was trying to get a sense of the order of magnitude of increase of resources required to have an adequately resourced system.
That's a really interesting question. The Victorian CPU, the Coronial Coroners Prevention Unit, has 28 researchers, some of whom are part-time, but I think they have about 18 or 19 full-time positions. The New South Wales Coroners Court or Coroners System has now 3 researchers, all of whom are working in to the domestic violence death review team. So there are no researchers looking at any other cause of death than domestic violence in New South Wales. What New South Wales does to try to meet that or address that shortfall is that when an inquest is held, coroners receive assistance from the Crown Solicitor's Office, who have solicitors and paralegals and others who may do ad hoc research for them, and they might also get expert reports from people in whatever field of expertise is thought useful, but it's a very ad hoc system. So if you were going to plan a better New South Wales system, basically you'd copy what the Victorians have done. So you would have something like 14 or 15 full-time coroners supported by something like 25 or so researchers and supporting ancillary staff, I think.
And that would include the family liaison officers that we heard about.
Yeah, but they're not researchers. But
No.
New South Wales has a team of family support officers, which I think is now up to 5, and the Department of Forensic Medicine has 4 or 5 counsellors. So if you amalgamate that group, if you like, family liaison and grief counselling is probably pretty reasonable in New South Wales. But they have nothing to do with preventing future deaths.
No, but certainly what we've heard throughout the hearing so far is that many of the families don't appear to have been offered the option of an inquest. The support to them has been either non-existent or very minimal. So I'm just trying to get a sense of what an adequately resourced system might require.
Well, I think Victoria is the answer, really.
And sorry, just to ask Ms Coates, if a unit was to be established that was to look at defence and veteran suicides in the same way as the family violence-related deaths, then we would be talking about additional resources.
Yes, to do the job properly, undoubtedly additional resources would be required. Commissioner, just to assist you with respect to your question about the resources required, my recollection of the last annual report of the Coroner's Court is that the family violence unit, so the death review unit, I think I'm correct in my recollection of this, has 3 full-time equivalents in it. It has its own dedicated family liaison officer. So that person, of course, specialised in the nature and circumstances of those particular deaths and a much deeper specialised understanding of the way in which the system works, and for obvious reasons of greater assistance and support to the families involved in those processes.
Thank you.
I think there's also, there's a solicitor, a family violence support officer, and case investigators that sit inside that unit. But for your assistance, that information is, I think, fairly readily available by the contained in the published report of the Coroner's Court of Victoria.
Thank you. And
Sorry, Commissioner, may I add one point? The Productivity Commission every year in its report on government services costs the recurrent expenditure for each of the Australian jurisdictions. And we find, if you examine that report, you'll find that the Victorian system costs around about $20 million recurrently. None of the other states or territories cost anywhere near there. But if you think about it, that is a tiny drop in the bucket in terms of what is spent on public health and safety and other things. So in order to get a really good Australian coronial system mirroring what's happening in Victoria, this country would not have to spend a large amount of money compared with the health budget, for example.
Thank you. I have two other questions, if I may. One is just around understanding legal representation for families at inquest. Do any of the jurisdictions provide that?
Well, New South Wales has a limited legal aid support service. I think there are 2 lawyers at the Legal Aid Commission, and I believe that it's free without means test for people who die in custody or police operations, but otherwise I think it's means tested, as with all other legal aid grants. So in my experience as a coroner, and I'm sure Ms Cope would have had the same experience if the Victorians don't provide legal aid, is that many families are not legally represented. And so their issues and their concerns are really addressed largely by counsel assisting, who talk to them and try to work out what their burning issues are.
Okay, thank you. And could I just ask one other unrelated question? Mr Freckleton, Dr Freckleton, you spoke about the potential for a Commonwealth Coroner's Court. Can I just clarify that that would not extend to encompass ex-serving defence personnel?
It would be more strained to justify its doing so.
Thank you.
Not impossible, but it would be problematic.
Thank you very much.
Commissioner Douglas?
Continuing along the line of, if not a Commonwealth Coroner's Court, what could you envisage a Section 96 grant to the states conditional on extension of the research activities of coroners' courts generally in the states to cover these sorts of issues which might be thought of as matters of Commonwealth responsibility, such as deaths in the military?
I could certainly contemplate that, and to the category of what we're focused on for this Royal Commission could be added a variety of other forms of death which take place amongst diplomatic personnel, AFP personnel, and even individuals who are not in Australia by reason of their being in territories, or we're simply being tourists who have died in problematic circumstances. But that would be dependent, of course, on referral power.
And also perhaps conditional on upgrading the coroner's powers in other states to make them similar to the epidemiological approach adopted in Victoria.
It would be important, yes.
Thank you.
Thank you. I have 2 questions, and I'll try and be as brief as possible, but please bear with me. The evidence that the 3 of you have given us today are incredibly informative, and I can assure you we have been hanging on every word. This is a matter that we view as very serious and definitely in need of insight and possibly recommendations. I want to ask the first question if I can, and Mr Dillon, you're excused from this because I'm going to quote from you, so I assume you agree with yourself. The 4 points that were outlined in Mr Dillon's paper in relation to the main purpose for a coronial system: 1, fact-finding concerning causes and circumstances of reportable deaths; 2, the prevention of death and injury; 3, therapeutic and restorative processes for the benefit of the bereaved relatives and others; 4, emphasising respect for life and protection of human rights, especially accountability of state agencies, and I assume he means state as in government, not necessarily a state government, and agents, investigation of unsolved homicides and suspected deaths of missing persons. If I could ask Dr. Freckleton and Ms. Coate, I think, and please correct me if I'm misquoting you, but you would agree with those four principles being, if not the sole four principles, certainly the cornerstone of the coronial system.
I'm comfortable with them being described in that way.
Thank
yes.
you.
As am I, Commissioner.
Thank you. So moving then to the second question, if I may. And I want to make two things clear. This Commission is not singling out any jurisdiction. There are problems probably in all 8 jurisdictions, some perhaps not as severe as others. And I also need to point out very clearly that this Commission and us, the Commissioners, have a very open mind on these many issues that we've discussed today. We've reached no conclusions or findings or anything else, but these are important issues that we must delve into. We have to reach conclusions ultimately informed by people like yourselves who have immersed themselves in this space, and you'll guide us with your many, many decades of experience, obviously. I'm going to move to a solution. Having agreed on what ought to be the backbone or the main purposes of a coronial system, I really appreciate the discussion in relation to a consistent federal system or Commonwealth system that oversights this across the 8 jurisdictions. But frankly, it's going to be difficult to achieve. And I don't know if this Commission can recommend something like that and not anything else. We're going to be looking for solutions. And I wanted to ask this question then. Would you consider some of these points as being doable sooner rather than later, while we may look at and recommend and possibly discuss a federal coronial system? 1, mandatory consultation with families before decisions are made as to whether to hold an inquest or not. 2, mandatory consideration and response to their wishes, particularly in relation to whether an inquest is desired or not. 3, an acceptance or reiteration of the need to examine the circumstances and causation of a death. Frankly, we have seen a lot of evidence where families' opinions, let alone their knowledge of the circumstances surrounding the death, played no part in findings. There was no counselling offered. All of that then leading to unsatisfactory findings being delivered, leading to more pain for the families across the jurisdiction. As alarming as it is disappointing. I would point out that while some have been handled very well, there are others who have not. So I guess while we await discussion and possible approval of a more consistent national framework, we must look for solutions that are implementable sooner rather than later. Some of these families have never been heard, and they must be heard. Can I ask your opinion, please, about what is doable in the short term, in the immediate term, so we can fix this problem?
Would you like me to start?
Sorry, yes, please, Ms. Coate.
Yeah. So, I agree with exactly the identification of the issues as you've laid them out, and it would. In terms of looking for a much more immediate solution, which no doubt is necessary, and an immediate response to enable a consistency of families being able to address all of those issues that you've outlined, I think that the Commissioners turning their minds to using an operational model like the Family Violence Death Review model embedded in each of the jurisdictions with appropriate resources, including family liaison officers to offer support, assistance and guidance to the families all the way through their experience of their interaction with the coronial jurisdiction, is a far more practical and doable model than waiting for the possibility of a federal jurisdiction and getting all of the states to agree to referrals of powers and all of the other complexities that are brought into such an equation. I just think a much more immediate, which is what's called for here, and practical solution would be that that the states and territories agree to adopt such a model if that were to be the ultimate decision of this commission. And as I said, implicit in that is the Commonwealth agencies and the Commonwealth itself agreeing to cooperate with the state and territory jurisdictions, because without that cooperation, the capacity for those units to do that work will be diminished.
Thank you, Ms. Coate. Dr. Freckleton?
Thank you. I'll answer in terms of the questions you've raised specifically, Commissioner. In terms of mandating consultation with families, it seems to me that there is much to be said in favour of that. I comment too that when these deaths occur, there is considerable distress for professional colleagues as well as family members who may have served for a lengthy period of time with the deceased person. Under Section 8 of the Coroners Act in Victoria, there are a variety of matters to which a coroner must have regard in terms of how to deal with a death. And that incorporates the fact under D that family members affected by a death being investigated should, where appropriate, be kept informed of the particulars and progress of the investigation. There is a similar provision in New Zealand, and there are good practices in Queensland in this regard. It seems to me that requiring ongoing communication with family members and others who have indicated a wish to be involved is absolutely fundamental to the process, ideally being therapeutic, but at least it's not being counter-therapeutic. However, requiring that there be an inquest simply because it is a death of a person who is a member of the armed forces or was, for the reasons already discussed, probably goes further than is optimal and unduly fetters coroner's discretions. And requiring that there be an inquest because family members express that wish also, in my view, goes further than is ideal. However, the kind of guiding of discretions that was mooted by Mr. Dillon is something that could be built into coroner's legislation around Australia so as to require the wishes of family members explicitly to be taken into account so that they can be participant in all coronial processes more explicitly. I concur with what Ms. Coate has said in terms of prioritising emulation of the family violence model. I comment that you get out of a coronial system what you pay for, and within reason, if more is expended on a coronial justice system, you tend to get a better, more sophisticated and more responsive system. And that is vital for many of the jurisdictions in Australia, which regularly are starved of funds that impact upon the number of inquests that can be undertaken, the quality of those inquests and investigations, and even the kind of counselling that's made available for bereaved family members. I concur too with what Ms. Coate said in terms of the need to secure cooperation from federal agencies, because even if you have a system such as exists in Victoria, where entities are mandated to apply, my view is stronger than that of Ms. Coate. I don't think that that provision extends to Commonwealth agencies, but one would want it to. If recommendations are made to any Commonwealth agency, including those related to the armed forces, it really is important in the public interest that they respond candidly and constructively. So having a memoranda of agreement or other arrangements by which that was agreed to by federal agencies, in my opinion, would be very constructive.
Thank you, Dr. Freckleton. Mr. Dillon?
Well, I entirely agree with everything my colleagues have said, but if I could just add a couple of other points. The Council of State Coroners, or State and Territory Coroners, which is the group of people who run these coronial systems, I think would be very interested in the concerns of and the experience of this Royal Commission and those who've given you evidence about their lived experience. So I think most of them would be shocked and probably horrified to hear what you've just been talking about, Commissioner. So I think they would be interested to know this. And then secondly, it may be interesting to ask them, if that is the case, what steps might be taken at the local level in these jurisdictions. That's one point. The second thing is this. In terms of resources, and it comes back to what Commissioner Brown was asking earlier, perhaps I should have mentioned it earlier. According to the federal government, the statistical value of an Australian life is something in the order of $5.1 million. That's quite a lot of money for a bean counter, but really when you think about it, if the Victorian system costs $20 million a year, and if it could save 4 extra lives a year, it pays for itself. As the community is ahead of the game. And so that argument can be made in every jurisdiction. But lives obviously have far, far more value than a simple monetary tag that you can place on it. But given that we live in an economic society where people do measure these things, then it seems to me not to be a very great expense to actually buy a good coronial system, as my colleagues have been arguing.
Commissioner,
Thank you, Mr. Dillon.
Sorry, Commissioner. Commissioner, I have one question.
Sure.
This question arises from out of Commissioner Caldus's question, and it concerns the very, very few inquests that have been conducted into the members of the Defence Force and veterans' deaths by suicide. Now, there's no statutory limitation, is there, on inquests, and inquests may be reopened, or the inquiries may be reopened, and there would be nothing stopping members of the families of the members of the defence who have died, or veterans who have died, from contacting the coroner and requesting that further steps be taken. Is that correct?
To whom is it?
Mr. Dillon.
Okay, well, in New South Wales, there actually is a limit, but it's 100 years, I think, or 100 years in 1 day or something like that. Yes, and within the last 100 years, anybody can propose that an inquest be held. So, but one of the things, if I may just touch on this, Mr. Connor, that you didn't touch on, I think, or maybe we didn't explore in great detail, the police report doesn't tell coroners whether a person who has died is or was a member of the Defence Force.
Yes.
And so it may have to be, this news may have to be relayed to coroners by families. So I think the standard report form needs to be amended to fix that.
Families could approach coroners around Australia.
Of course, yeah, of course.
And that's the Victorian position as well, Ms. Coate?
Oh, I think Dr. Freckleton was about to respond.
There are some inhibitions in this regard, because if a coroner has already made a finding, albeit not in an open inquest, there needs to be a sufficient reason to, in effect, reopen an inquest, which generates cost, but more particularly causes considerable distress to a whole variety of people. So it isn't that simply people can have a second go at an inquest, and because they now would wish there to be an open inquest, procure one, unless they can point to sound reasons which may not have been available first up to justify such a course. But Ms. Coate could tell you more about that.
No, I think you've articulated that well, Dr. Freckleton. Thank you.
Dr. Freckle, is this where inquests have previously been carried out? That's one situation. There's other situations where there's been no inquest. And is that subject to the same limitations?
There's an important distinction to be made here, Mr. Connor. There are investigations which result in findings in many scenarios without there being an open inquest. And once there are findings about a death, they might be very short form ones, then the onus is upon somebody who wishes to disturb that or to have an inquest convened to justify such a course.
Thank you, Dr. Freckleton.
Sorry, could I ask a supplementary question to that? So just to explore that a little further. So in the event that a family was not aware they could ask for an inquest, the coroner made a finding. Would, in your opinion, Dr. Freckleton, would that constitute sufficient cause for the family to be able to go back and ask for an inquest?
No, that per se would not be enough. There would need to be new facts and circumstances to which the family member could direct the coroner, particularly information to which the coroner wasn't privy at the time of arriving at her or his findings.
I promise this will be the last question.
Sorry,
If the question was asked that the family not only wasn't asked if they wanted an inquest, but were never spoken to, no statements were obtained, and no members of the family informed the coroner of the circumstances surrounding the death, would that be grounds in your view for reopening the inquest?
Commissioner Cardless, I don't want to be insensitive about this, but generally I would think it would not be enough. It's terrible practice if that has occurred, but what the family members would need to point to is information to which they are privy, which would impact upon the correctness or otherwise of the findings arrived at by the coroner. But it might be helpful to hear from Ms. Coate for her perspective.
Well, Dr. Freckleton's right. It's terrible practice, and can I just take a sidestep for a moment, Commissioner, just to say that I don't want to leave this session today with the notion that the Victorian system is not without its problems in practice, and that mistakes get made, things don't happen as they should, and there is a process certainly of continuous improvement that happens inside the court, as is essential to any agency indeed, and people should be encouraged to express their concerns directly back to the court if what you're describing has happened in the Victorian jurisdiction has happened, because obviously that is completely inappropriate practice.
Could I add one thing there, though?
Yes.
In Victoria, there are findings made in most cases, I believe, but in New South Wales, that's not the case. There are only full findings made if there's an inquest held. So coroners under, I think it's Section 34 of the Coroners Act, report to the Registrar of Births, Deaths and Marriages concerning the identity, date and place and physiological cause of death. They don't record anything about the the circumstances of death. And that's a real distinction from what Dr. Freckleton and Ms. Cotter talking about. So in that case, there would be a real opportunity in New South Wales at least for families to say, hang on, you haven't really explored this, and here is some information. I think in practical terms, there would have to be fresh evidence or fresh ideas, or at least that families would have to point to something that wasn't properly investigated. But that opportunity would be there, I think.
I appreciate that, thank you. And we are aware there is currently a parliamentary inquiry in New South Wales into the coronial system, and we're obviously watching with interest. Mr. Connor?
Nothing further.
Nothing. Thank you.
Might the witnesses be released from the summonses that?
Yes, you're released from the summons. And again, I just want to thank you on behalf of the Commission for your time, for the amount of material you've given us to think about. It has been incredibly beneficial and we appreciate it. And thank you for allowing us to go over time.
Thank you.
Thank you.
We'll adjourn now, and I understand we're convening at 9 a.m. tomorrow.
Yes, to hear an international expert who will be at 9 a.m. together with Ms. Sue Murray.
Thank you. We'll adjourn.
All rise. The Royal Commission will now adjourn.